Yes.
Well, two motion matter last night. I'm praying for listing on Friday last night.
Motion.
On
Monday.
Friday last night. Monday I will not be available because of election last night.
Okay, Friday.
May I please beg to mention for early listing, your lordship. In this case, your lordship, the co-accused has granted bail, your lordship.
Matter is fixed when?
Fixed 8 this month, your lordship. Your lordship, kindly on tomorrow, your lordship.
Let's have a talk with them, CD, which case, where granted. Just
Sansari PS, your lordship. Earlier occasion yesterday was listed, your lordship. That case was fixed for CD on 8, your lordship. And in this case, your lordship, another accused has released on bail by the ADJ number 2, Amingaon, your lordship.
Let it come on
Let
next, lordship.
Lordship, on tomorrow, your lordship.
How can? If it is
Yeah,
fixed,
One order I have.
one order has been passed by law court. If you say that I will withdraw and go to the CGM, that is a different issue.
Then I
Because see, we can give a direction, no issue, but they will have to have the case diary,
yes, lordship.
is not it?
Yes, lordship.
And case diary is all likelihood in there.
Possible,
It's
lordship.
B or AB.
BA, lordship. BA, lordship. Behind the bar, your lordship, as on today, 35.
No, understand, we
Lordship,
understand everything.
lordship.
Problem is this,
Lordship.
already a date is fixed. A
Lordship.
judicial order is there.
Yes, lordship.
Until and unless something that you can show that yesterday bail has been granted by this court, then of course we can call it.
Yeah.
But it has been granted by somebody else.
And perusal of the CD will be required. Lordship. Let it come on 8th. Lordship.
If possible, your lordship.
What are the offenses?
Lordship.
Offenses are what? Under
Offense, your lordship. 392, your lordship.
392.
Robbery, your lordship.
CD will be required.
Lordship.
Yes,
Lordship.
PP, what you say?
Lordship.
Can you give a try tomorrow calling for the case
wait.
diary a little bit early?
Concurrent.
See, a person's ultimately a person's right. That is what concerns
In that
us.
case,
We may reject it also. That is a different issue. Okay, tomorrow we'll see it.
Obliged.
May it please your lordship.
Yes.
My lord, I am praying for a little out of the turn accommodation today, my lord, because my lord, there is some urgency. We have filed a bail application on behalf of a learned member of this bar association, my lord, who has been apprehended just few days back on making some remark on some alleged proposal of the government, my lord, for which he was my lord, apprehended.
Now,
from his-
whether 439 or 438.
My lord, it is a regular application before your lordship, and one bail application we have moved before the learned court of the additional CGM, which was rejected, my lord, 2 days back. So we have come immediately before your lordship, my lord.
You want to move it when?
My lord, today too, if it is not inconvenient for my lords, my lord.
We don't have any inconveniences. If you can bring it, bring it.
Yes,
We'll
my lord.
see.
I have already done the e-filing, my lord. I have received the number. If your
But
lordship-
case will depend upon
The case
the
diary.
facts of the case.
Of course,
It's,
my lord.
this court will not look
Of course,
into
of course,
whether
no,
he's
no,
a
no,
lawyer or a
no,
prime
no, no,
minister.
no, my lord. Of course,
Yes,
my lord. I just need your lordship's my indulgence, my lord.
permission is given.
Okay, I'm highly obliged, my lord. Deeply obliged.
May it please your lordship.
Add to, my lord.
No, don't say at 2. Within the day. We do not know. If
Yes.
we finish the list at 1:15, not come at 2.
No problem, my lord.
That is what happened.
Yes, my lord. I'll come.
May it
Yes.
please your lordship. Respond number 4, my lord, in item number.
But it should be above 7 years.
My lord, the task section which was imposed was under section 66F of IT Act, which is above 7 years, my lord.
Affidavit of person filed yesterday by respond number 4, may kindly bring to the record.
You want to call affidavit?
Yes.
Yes.
All right.
May I please, my lord?
Yes.
My lord, I am praying for adjournment of item number 45
45.
for today, my lord.
Not today. It's hearing or what?
For crossing, my lord.
Enforcement. Okay. Any interim order?
No, my lord, till now.
On the prayer of the learned counsel for the petitioner, release this matter after 10 days.
Okay.
Your lordship.
Yes, diary.
Lordship.
When?
9 lords.
Ninth.
End of this month.
Ninth.
Not of this month.
Diary.
I think because
What do you
30
think so? We
Then
were
your lordship-
thinking of granting you bail. What is this? Go to the affair.
page 17. Sorry, page 8, my lord. Page 18, my lord, the forwarding report. my lord.
Okay, case diary. Short date, give us short date.
Eight. Well, the file was just handed over to me, said, "Madam, you will go for a case diary, maybe court for." I'm obliged, but
These are the cases ultimately, nothing is there, yes.
Is there any call for?
In, this is some supari,
Yes, already covered lots of everything.
no, already recovered, you understand, but there are some other cases. AB, I think, another AB is there, somebody is
This is
apprehending.
related to Lordship Jogi Ghopa police station.
Jogi Power Kharupetia,
This is Jogi Ghopa Lordship and
okay,
with the petitioners,
okay, CD.
Lordship petitioners were not named also, nothing.
No, understand, but
Yes.
this is happening, yes. When?
10 lordship.
10th.
Apply that.
Yes, madam.
Lordship, FIR is at page number 11, Lordship.
When?
10 lordship.
Huh?
10.
10th. 10th.
Application, madam. And connected cases is
Uh-huh.
6
When?
of this month, 6 of this month,
6th.
6, madam.
CD 6.
And my lord, item number 9, same FIR
Okay.
and 6, madam, along with BA number 1213 of
But
2020.
why you apprehend here?
My lord, my name is there, my lord.
Your name is there.
Name is
Okay. When it is on 6th?
6, along with the postmortem report.
Okay, along with the postmortem.
9, no? 6 or 9.
CD along with the postmortem.
No, 5 and 9.
Sorry, 5 or 9.
You are saying about 5 and 9.
5 and 9.
Yes.
Problem.
48 days in custody, Lordship. And no custody was sought for.
Where is the affair?
FIR is at page 8, Lordship.
He was playing in the breeze. And initially there was no allegation. Subsequently, somebody might have said. The child was playing in the admittedly. In the breeze, and his body was found later on from the water. Considering the period of detention to the satisfaction of
CGM Naga.
CGM Naga 25.
Deeply obliged.
Nature of allegation and period of detention.
May I place your Lordship? Lordship.
When?
10 lordship.
10.
May I place your Lordship? This is 439 application, Lordship.
Definitely.
Yes.
May please, Lord.
8 or 9.
Lord, 410 bail application, Lordship.
Huh?
Matter pertains to alleged recovery of Lordship fake gold, Lordship. And Lordship, the petitioner is behind the bar for last 18 days, Lordship. Nothing was recovered from his Lordship house or possession.
Okay, we'll see you are in the record or not. When?
10 lordship.
10.
Obliged. Check. 410 application, let's check. FIR is on
This is item
48.
48. Yes, where is the affair?
FIR is on page number 14.
Nothing lordship.
Right,
Previous.
Chancellor, that page 14.
When you were arrested?
Lordship, forwarding is of 21.
21. So,
When?
10. Lordship.
10th. Kothakor, next week. Don't want to pass a order of dismissal at motions.
No, your lordship, this is not decided by this honorable court, your lordship, in a similar, managing director is not responsible, your lordship. I can place that judgment, your lordship may kindly go. And there is no averment that in the publication of the news, I have any role, your lordship.
That is there.
Not a single, even in their statements, your lordship, before the learned court below, your lordship. That, your lordship, or high court's judgment, your lordship, in respect of the same scenario, your lordship.
Heard Mr. Bothakor, learned counsel for the petition. Only for so far relating to this man.
Only him.
Not heard.
Others have not come.
We'll examine this.
Lordship.
Since you are placing a judgment,
Lordship. Para 8 is very clear, your lordship.
we'll see
Lordship.
whether this is binding or something else is binding upon us.
Lordship. Supreme Court judgment is also this.
Heard Mr. Bothakor, learned counsel for the petition. The present application is filed under section 482 CRPC. With a prayer to quash and set aside criminal proceeding in CR case number 2768/2021 under section 500/34 of IPC pending before the learned judicial magistrate first class Kamrup Metro. Full stop. The basic ground of challenge is that the petitioner is the managing chairman cum managing director of AM Televisions Private Limited and private limiteds, and without there being any specific attribution to him as regards commission of offense under section 499.
Lord.
499. 499. The managing director shall not be liable for prosecution under the aforesaid section. In this regard, Mr. Bothakor has relied on judgment of a coordinate bench passed in criminal petition 33 of 2015 to contend that, where is the paragraph?
Para 8.
Para 8, to contend that para 9. Where is that?
Para 8, your lordship.
To contend that content that
8 and 13, your lords.
13 it should be.
8 and 13. Next page 13. Chairman and managing director of a news channel can be held liable for publication.
Content that chairman and managing director of a news channel cannot be held liable for publication of offending news. Offending. Full stop. This matter is further consideration. Full stop. Issue notice 4 weeks. Steps within 5 days. Give a date. Considering that the petitioner is stated to be a managing director of the news broadcasting company, and also considering the ratio laid down in the aforesaid case. Uporat dekhi diba Dipanita Jaiswal tumi je kolu criminal petition Dipanita Jaiswal versus Swenchu sai loba aru with supra kori diba in the ratio laid down in Dipanita Jaiswal within bracket supra. This court is of the view that petitioner have been able to make out a case for an interim order. Accordingly, it is provided that further proceeding so far relating to present petitioner in CR case number so remain suspended till the return of the petitioner. Yes.
After a few minutes,
What are these? That affidavit. Yes, Ahmed.
And CV is there also.
Where is the FR?
That your lordship will find page 11. So the final complaint that page 19. He is in custody for 2 years, 9 months, 10 days as on today.
Charge sheet not, charge sheet file.
Charge sheet submitted out of
Where is NCB?
I have tried to contact them. Lordship may take it after some time.
After some day. Who is NCB standing counsel?
SCL.
Somebody should go through it. So that
22, I have to go through the LCR after some time. I will.
LCR concern are not on that on merit, my lord. CBI did, my lord, notice has been issued. It is a non-able offense, my lord. The Supreme Court says, my lord, if he was not arrested during the course of investigation, because I am declared absconder by an investigating officer, which he has no power, without following the mandatory policy section 81, 82, 83, my lord, investigator declared me absconder, which is clear from the page 20 of the charge sheet, my lord.
you want to go through the case
I
there
have
with,
not gone through. That's now.
are you having any objection?
No, my lord.
Then
No.
that is what is his prayer.
23. In hearing.
CD received. Lordship.
Item
23.
BA or what? AB?
AB lordship.
Wait for some time, otherwise you'll CD is there.
It is there.
Any interim order? No.
No lordship.
We'll wait for some time, otherwise we'll discuss it. Yes.
24. Jail appeal lordship, LCR received long back, but paper book not yet prepared. 10 years imprisonment, more than 6 years already passed lordship.
10 years imprisonment, more than 6 years past. LCR has received? Yes, skip the LCR. Any IA?
No lordship, I have no document because I am an amicus, so paper book has to be prepared.
We also do not have any.
Okay. Nowadays, what single judge, single bench cases? also-
Compilation of documents in,
Okay.
if it is in Assamese, then also.
Okay. The LCR, this appeal was admitted on 16/11/2020, full stop. LCR has also been received. Registry to prepare paper book and furnish it to the learned amicus.
They also need.
Amicus and public prosecutor. List thereafter.
25 along with article 49.
List it before any other bench without me. 25 and 49.
This is your lordship. Lordship will peruse office note dated 22/4/24.
What it says?
Lordship, the no service report has come from the OC Bogan because it is under a POXO lordship. Bogan
Okay.
NDPS.
Office note dated 22/4/2024 reflects that no service report has been received from the officer in charge, Boginodi Police Station, Lakhimpur. From registry to issue reminder in terms of issue reminder and list this
or-
matter.
Maybe after 2 weeks, lordship, because it is police, not a AD or something. And lordship, the LCR is received, so the registry can prepare the
In the
paper.
meantime, as the LCR has been received, registry to prepare the paper book and furnish it to the learned councils, including the amicus.
Highly obliged.
27.
Yes.
Lordship, in this case, I am amicus and I have collected some information as per direction of this honorable court from the district legal services Jorhat, and I have found that on last 15th of August he was remitted. Remitted. That has been communicated to the High Court legal.
So what to do?
Probably it will be dismissed on withdrawal. Earlier he has filed one application for withdrawal to this honorable court, but Honorable High Court has directed, since in the petition, the ground was not cited. Accordingly, I was directed and I have collected this much of information.
Okay, where do you get that information?
Last page, last page,
Last page.
last page. That is it. On 15th of August.
Okay, is it reflected in? Okay.
Item number 2
Full stop. The appellant preferred an application
It is in the flag C, Lordship. Flag C is his application from jail.
preferred an application to withdraw the present criminal appeal. However, as no ground was cited, a direction was issued to
To contract with the District Legal Services, Jorhat.
to direct it to the amicus.
Lordship, that order is on 14/9/2023.
Okay, accordingly, as no reasons were cited in the said petition as to why the appellant intends to withdraw the said appeal, the learned amicus curiae was requested to have interaction with the appellant and seek necessary instruction as to the reasons of filing this petition for withdrawal of appeal. Accordingly, the learned amicus contacted the appellant through the
District Legal Services
through the
Authority of
Legal
Jorhat.
Services Authority, and a status report has been submitted to the effect that the petitioner has already been released from jail on remission being granted by the state. That's
On last 15 August of 2023.
on last 15th of August 2024.
Lordship, that.
In view of the aforesaid, the prayer of the appellant to withdraw the present appeal stands allowed. Accordingly, this appeal stands dismissed on withdrawal. Full stop. Registry to pay the remuneration to learned amicus in terms of the estate norms. Full stop.
Much of that.
28. This is also same lordship, 10 years, 6 years past, LCR received, paper book not yet prepared.
আগতে order to দিলো
24,
20
24.
ওরা যেটা order দিলো লাগত কি পারিবা as the accused appellant has already passed more than half of the sentence, registry will expeditiously prepare the paper. দুইটাতে add করে yes
Obliged lord. 29.
B Sharma will লিখিবা amicus is present. Yes, what is it?
As per the last office note, it's still shown that we are not taken steps,
Hmm.
but steps were taken on 9/11/2023. The case status system shows that.
Okay, office note dated 29/9/2023 reflects that no steps has been taken by the council for the
Applicant.
applicant. However, Mr. Bhattacharya, learned counsel submits that steps were taken
9/11/23.
on 9/11/2023. Okay, registry to verify and list this matter after 2 weeks, with a updated service report. Yes. With an updated report, yes. Yes, where is the other side? The private parties, yes. Somebody said that somebody want to argue or something. You don't have any problem in having the. You on last occasion made a submission that you do not have any difficulty in having a fresh inquiry.
Exactly.
That is correct?
Yes, Lord.
Yes. Just wait for some time. Let us finish the other small matters.
My lord,
Orders matters, we'll then start dictating this order.
my lord.
Just wait for some time. just assist us regarding the facts, recording the facts. Yes.
One.
30. This is same. Same.
30 and
This is
31.
same. 30 and 31 same.
May I please, your lordship? As per office note dated, lordship 17/2/2024. We have taken dusty service, lordship, and if it also been filed and tag on, lordship. Kindly matter may be fixed for hearing, lordship.
Where is the dusty order? Where is the order of dusty? By which order you were permitted to take steps to dusty? Okay. This court while admitting this appeal under its order dated 5/6/2023 permitted the appellant to take steps for service of notice upon respondent number 2 through dusty. The petitioner has taken such steps to dusty and filed an affidavit. The affidavit reflects that the petitioner, appellant approached the respondent number 2 to serve the notice along with copy of the memo of appeal in presence of 2 witnesses, namely one Mohram Ali and one Muhammad Jabbar Ali of the locality. But says respondent number 2 refused to accept the copy of the notice. In view of the aforesaid stand in the affidavit, the notice upon respondent number 2 is deemed to be served. Accordingly, this matter is ready as regards service. Full stop. According to Nalaga, this matter is ready as regards service. List this matter for hearing in its own turn.
Applies, lordship.
Yeah, please.
Yes.
In respect of order number 13/3/2020. As per order dated 13/3/2024, my lord, dusty steps has already been served, my lord. But in respect of registered step, my lord, service report is awaited.
Appeal is admitted. Full stop. The appeal, the present application is filed under section
354. Oh, sorry.
Not 354. This application is filed for suspension of the under section 389 of the Code of Criminal Procedure 1978 for suspension of sentence passed by the learned special judge Kachar in special POCSO case number 14 of 2021, convicting and sentencing the appellant under section 354 IPC and to undergo rigorous imprisonment of 2 years. Full stop. The connected appeal has already been admitted, and this court under its order dated 25/7/2023 suspended the sentence by order dated 25/7/2023 allowed the petitioner to remain on previous bail. Full stop. As the connected appeal has already been admitted, the present IA stands closed. Stands closed. Full stop. The petitioner shall remain. Petitioner is allowed. Appellant is allowed to remain on previous bail till the disposal of the connected appeal. I stand disposal. Yes.
My lord, in this case, my lord, engaged counsel's father is in bedridden condition, my lord.
Okay, learned counsel for the applicant. Press for an adjournment. Full stop. Same is granted. Same is allowed. List after 3 weeks. None appears for the petitioner on call. None appears for the petitioner when the matter was listed on 2024. Accordingly, the present petition stands dismissed for non-prosecution. Interim order, if any, stands vacated. None appears for the petitioner on call. List after 3 weeks.
Well, 6 days delay. 6 days delay.
This is listed for first time.
Second time, my lord.
Second time. In preferring criminal appeal, what is the offense?
Offense is under section NDPS Act, my lord.
Why?
Because he's from Bihar, my lord, he has to.
Why Sub-Inspector of Police is a party here?
He was the informant, my lord. So as per norms, my lord, we'll have to make him a party in it.
Heard, Mr. Ambitious Learned Counsel for the petition. The present application is filed under Section 5 of the Limitation Act 1963 for condonation of delay of 6 days in preferring the criminal appeal. The delay is explained at paragraph
At paragraph 4.
paragraph 4 of the petition, and it is projected that purpose of consider the same and perusal of the same. This Mr. Taragokil peruse the same. Explained in so paragraph number 4. Then you write it. Mr. Bothakor, learned additional public prosecutor, submits that since delay is only for 6 days, and
In my petition, delay is written as 49 days.
It is handwritten. Handwritten.
Six, that was deleted by registry.
Yes, sir.
Yes, it's okay. Okay, Bothakor
Yes.
submits that since the delay is for 6 days, the state will not object condonation of such delay. Considered the the statements made at paragraph 4 as well as the submission of Mr. Bothakor. Considering the matter in entirety, this court is of the view that the petitioner was prevented by sufficient cause in approaching this court in filing the connected criminal appeal. Accordingly, delay stands condoned. Registry to register the connected appeal, and list after list thereafter. I stands dispose of. The present application, none appears for the petitioner on call. The present application is filed to implead the complainant of CR case number 591/2023 as party respondent in the connected criminal petition number 393/24 as respondent number 2. Full stop. Respondent number 2. The connected criminal petition is filed as for quashing the complaint case number complaint case being CR case number 591/2023, and therefore the complainant will be a necessary party for proper adjudication. In view of the aforesaid, the present application stands allowed. The applicant allowed accordingly. The complainant in CR case as reflected. Complainant in CR case that is opposite party number 2 be impleaded as respondent number 2 in the connected criminal petition. Accordingly, I stands disposed. Mr. Bora,
Madam.
why don't we hear the matter? Why do it in piecemeal? We'll hear everything on IA. Huh?
When?
Maybe today, maybe,
Yes, but
maybe
I'm ready.
next week. We don't have any problem. Subject
Today?
to what is it? I think why should we spend twice time in this case?
I'm ready, my lord.
Huh?
Today too, my lord.
My lord, regarding the whole appeal, my lord,
Huh.
my lord, I have seen, my lord, I have just without regarding the whole appeal, my lord, it can be taken up if it's tomorrow, my lord, because I have prepared regarding the bail part. my lord.
We'll give you
If you-
tomorrow.
if it's a
I
bail
thought,
part-
why should we?
Because
We'll do
because
the entire thing.
yes, my lord, yesterday, my lord, the thing is that it has come up only for the suspension of sentence, my lord. That is because it will be, then we have to make a detailed argument, my lord.
You start today.
Yes.
Right
yes.
now, my lord.
Not right now. Let us finish this smart matters, then we'll. Let us have an understanding today, then we'll hear it tomorrow.
If required, my lord, I will.
Yes,
If not,
yes.
if it is your I can satisfy my lord today itself. If it is not,
Ah,
my lord,
yes.
then I can.
Yes, yes, yes. No issue on that.
I'm obliged.
Lordship, in this matter, I am appearing for respondent number 1.
Respondent number 1.
Lordship, I'm trying for listing this matter for hearing in the next month, any date.
You want
For
to file
final-
objection?
I filed objection.
You have filed.
Yes.
You wanted accommodation today?
Accommodation.
Yes. Learned counsel for the respondent. Press for an adjournment. Prayer is allowed. Please this matter.
Any date. Next.
Give a date. You have taken an adjournment.
On 15th, your lordship met. Huh? No, 8 months.
15th of May.
About 20 or 22 on this, that week I have some difficulty.
Yes. Tell us. it.
On 21, Lordship.
21st of May, 2024, interim order passed earlier. Shall continue.
All right.
Yes, Mr. Lal, what is this?
My complaint was dismissed, Milord, on the ground of lack of territorial jurisdiction, Milord.
Where is that?
Milord, the complaint starts at page number, Milord, 20.
Place 20.
Page 20.
Where is the other side?
The other side, the name has been shown in the close list, Milord.
Okay, where is that complaint?
Complaint is at page 20, Milord.
What was the issue?
Milord, it was a file for recovery of Sridhan, Milord, 406, offense under section 406, Milord. If your lordship sees, Milord, I am a resident of Guwahati, Milord. And if your lordship takes up the order, Milord, which starts from page number
11.
Lordship?
Page 11.
No, Milord, page number 27, Milord, is the order dismissing the complaint, Milord.
What is a judgment?
The judgment says, Milord, it is basically an interpretation of section 181, subsection 4, Milord.
No, that judgment of page 11, what is that? Annex 2.
No, there is a family court judgment, Milord. Divorce was granted in my favor by the family court Guwahati, Milord.
Okay, divorce were granted in your favor.
Lord.
Now you want your students to be returned.
To be returned.
Now why court is saying no jurisdiction?
Milord, kindly see page 27, Milord.
Yes.
I also perused the complaint petition wherein the address of the accused is in the district of Nagaon and Kanpur PS. As per the judgment of the Honorable Guwahati High Court in Rajiv Chakrabarti versus so and so, it has been laid down by the Honorable Court that the cause of action for recovery of Sridhan article arises within the local jurisdiction of the magistrate in whose district articles were delivered and allegedly retained. In the instance case, it is prima facie apparent that the Sridhan article have been allegedly delivered and detained in the district of Nagaon under Kanpur PS. In the light of the above decision, it dismissed, Milord, the petition, Milord. Now, if we have the
Yes.
copy of the judgment, Milord, first, Lordship may kindly see section 81, 181.
No, we'll go to that. Just I'm recalling something. Mr. Bora, you argued a matter regarding this Sridhan.
Yes.
What was the matter? I delivered a judgment.
Yes. Malad, regarding the Sridhan, Malad, there has to be some allotment.
Not to know
Yes.
that what was the judgment? Do you remember? You argued that case. I delivered a judgment.
Yes.
Any name or anything? Do you recall?
Gone out of my.
He may recall, yes. Okay, since he is not there, we'll fix it next week. I think
Ashok Kumar Rathi.
Ashok Kumar Rathi. Just write it down. Yes. Ashok Kumar Rathi.
Can it be on 14th of May, my lord?
14th of May. Though learned counsel for the petitioner is present, none appears for the respondent. Though name of the learned counsels are reflected in the cause list. However, in the interest of justice, matter stands adjourned. Though Mr. Lal has expressed some urgency. No, full stop. Mr. Lal has expressed some urgency in this matter. Accordingly, let this matter be fixed on when? 14th of May.
Deep level.
Your Lordship.
Yes.
For the petitioner, Your Lordship, against the interim order passed by the Family Court, Principal Judge number 3, Kamrup Metro, Guwahati, 22/6/2023, 1 year back almost. And now, Your Lordship, the case is at the advanced stage for the trial. He had the respondent here, who was petitioner in DV case. She was already getting 4,500 unchallenged. I have annexed here. Thereafter, in the family court, she also filed 125 CRPC proceeding. The principal judge there, she did not reflect this thing that she is already getting. Anyhow, it appears from the order sheet that on that very day, this petitioner before Your Lordship informed. However, since the order is simply that since he is a government employee, so till final decision of the case on Mary, he should pay also additional 3,500. So all the annexes, what was her claim, access and liability before the learned CGM in the DV case, there was from all 7,000. There she made 15,000. So now my submission is, Your Lordship, that without giving offense to Your Lordship, since it is the advanced stage of the disposal on Mary, so I don't want to press now, since I have been regularly paying.
Okay, the present application is filed assailing an order dated 22/6/2023, passed by the learned Principal Judge Family Court number 3, Kamrup Metro, Guwahati, in FC criminal case number 221/2022, whereby an interim maintenance effective from month of June 2023 was payment of interim maintenance. Payment of interim maintenance of rupees 3,500 effective from month of June 2023 was directed. The learned counsel for the petition submits that the matter has already proceeded and is in the verge of final conclusion. Accordingly, he will withdraw he would like to withdraw the present application with a liberty to raise all the issues that has been raised herein, if so advised after conclusion of the proceeding. Prayer is allowed. Accordingly, prayer is allowed. Accordingly, this revision petition stands dismissed on withdrawal with the liberty as prayed for. Yes.
Lordship, in this case, the petitioner is agreed by judgment on order dated 28/6/2023, passed by the learned Sessions Judge Bazali. It's a DV case, Lordship, domestic violence. What happened after filing of this case, the wife filed a divorce proceeding also before the family court, Guwahati. And in that case, the husband appeared. Now there is a development for compromise between the parties. Only the alimony parties left, but otherwise both parties.
The learned
may I pray, Lordship, that matter may be sent to the mediation here, High Court. He is also agreed.
Okay. The learned counsel for the present revision petition involves a dispute between the petitioner husband, petitioner wife and respondent husband. And both the learned counsel for the parties have submitted that the matter has almost been settled between the parties, amicably settled between the parties. Between the parties. However, the finality to be however, the quantum of alimony is not yet been decided. Accordingly, both the learned counsel for the parties have made a joint prayer that matter may be sent to the mediation, Guwahati High Court Mediation Center for a mediation. Full stop. Considering the matter in entirety and submission of the learned counsel for the parties, let this matter be, the record be sent to the Guwahati High Court Mediation Committee, and thereafter the mediation committee shall appoint a mediator to amicably settle the present dispute for the purpose of amicable settlement of the dispute between the husband and wife. Yes.
Obliged, Your Lordship.
Appeal is against conviction.
Release thereafter. Yes, Munir.
Appeal is against conviction, my lord. The appellant
Admit.
is
What is the conviction?
conviction, my lord, under 304 part 2.
What
for
is the
10
sentence?
10 years and 324 for 2 years.
10 years and 2 years. Okay. Admit.
Concurrently.
Admit. Admit koribo. Any IA?
IA there.
IA notice admit notice of koribo. IA notice dibo. This IA will be considered after receipt of the LC.
May I please?
Yes.
Lordship, statutory appeal, Lordship, convicted for 10 years under section 10 POCSO.
Same order.
5 years.
Same order. Notice to private dismissal. Silo. Within
Lordship, alternative mode may be allowed, Lordship.
Okay. Dusty is allowed.
Okay.
IA nahi hai good. Ito to aise nahi.
But it is an
Just a minute. Just a minute. Just a minute. This is IA, huh? Same IA. Yes.
Please, ma'am.
18 or 19. Huh? Yes.
Conviction, Your Lordship. Conviction
Admit.
under section 14.
Any IA?
Not
No,
yet.
not it. Okay. Statutory appeal. What is the sentence?
3 years, man.
3 years. Admit, censure. What is the IA?
IA 400, 2024.
What was the offenses?
Offenses under the 304 part 2 matter.
30 part 2. Any where is the FIR? Anything on record?
My lord, I have annexed, my lord.
Who is the informant? PW?
Informant, my lord, brother.
PW?
PWs are there, my lord.
No, what informant was examined as PW?
PW1, my lord.
Okay.
4, 5, 6, 7, my lord, did not support their case, my lord.
What is your name?
Zakir
Zakir Hussain Loskor.
I have annexed, my lord, PW.
Just give me a minute. Any eyewitness?
Yes, my lord, 4, 5, 6, 7, all are eyewitness, my lord. Actually, my lord, he was drunk, my lord, watching. my lord,
PW?
PW4, my lord.
Wife was witness
No,
to the situation? No.
He was hearsay witness.
Huh? Hearsay. Who are eyewitnesses?
Eyewitnesses, my lord, 4, 5, 6, 7.
Page.
Page, my lord, 21. In the memo of appeal, my lord. He said, my lord, the petitioner rather, my lord, helped her, my lord. Mitton, my lord, his nickname.
Heard. Mr. A.M. Borguya, learned counsel for the petition. 3 years. The decision application. Where is the IA?
IA
Decision-
400 number.
Decision application under section 389 CRPC. Praying filed with a prayer to suspend the sentence sentence passed in connection with judgment and sentence dated 28/3/2024 passed by the learned session judge Hailakandi in sessions case number 126 2017 under section 304 within bracket B IPC and was sentenced to undergo rigorous imprisonment of 3 years along with fine of rupees 20,000 in the 20,000 full stop. The connected appeal assailing the aforesaid judgment and sentence has already been admitted. Full stop. The learned counsel for the petitioner has annexed all the depositions of the witnesses along with the appeal memo. Peruse the same and considering the testimonies of the alleged eyewitnesses, that is PW
4, 5, 6.
Seizure 4, 5, 6. This court says this court is of the view that petitioner has been able to make out a case, for interim protection. Accordingly, it is provided that the petitioner shall remain on previous bail till previous bail.
Bail. At present, he was
Previous bail till disposal of the connected appeal. Highest sense disposal of.
Your Lordship, kindly the matter may be passed over for the time being.
No time being.
My senior is on
Learned on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after a week. Yes, next.
I'm in for adjournment number 2.
Okay. Yes, next. None appears for the parties on call, list after a week.
41.
Yes.
Lordship, I'm for item number 40.
Item number
40.
1? 40. Yes.
The engaged counsel has returned the brief. In the meantime, we need to take some instructions.
Okay, on the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 10 days.
Apply, Lordship.
41.
Yes.
Yes. Yes,
By the
Goswami.
way, this petition were challenging the proceeding.
Uh,
There was a complaint earlier,
Uh.
and that complaint was forwarded before the concerned police station.
Hmm.
Accordingly, matter was investigated by the police personnel, and matter is resulted in FR, final report under section 173. Then for acceptance, one notice was served to the informant. Then legal hair of the informant
come before the court, and accordingly he pray for substitution, and thereafter my lord, he prefer my lord, that complaint reproducing the contents of the earlier my lord, complaint, and accordingly matters my lord, revived, and someone has been issued, and thereafter we will come before the court that my lord, there is my lord, cause of action is not survived. That's why the matter is my lord, continuation of this proceeding is my lord, abuse of process of law. On that ground, we are before this honorable court. Lordship may kindly, there is my lord, complaint.
Where is that?
Yes. Page my lord, 16 onwards.
This is the first complaint.
Yes, my lord, this is the first
Which-
complaint.
which-
And the second one is my lord, 37 million. Well, same contents are reproduced here. Well, matter relates to well, forgery of a gift deed.
Okay, then what happened here, sir?
Yes, my lord. Therefore,
Who lost this affair? Which? This was filed before the Chief Judicial Magistrate by the sons and daughters of the donor.
no, my lord. Complaint was well, yes, well, son. Earlier one was well, son.
1, 2, 3, 4, 5 are the
Petition.
one who is the complainant is
Ramesh Deka.
Ramesh Deka.
Yes,
He is the
son of the
son of the donor.
Yes.
Okay, then what happened? This was forwarded to for registration FIR.
Yes.
Then
Then it was investigated, my lord.
Mm.
And thereafter, my lord,
Mm.
FR has been filed. And that
where is
may,
that? Any scan copies you are called for?
yes, my lord.
Huh?
Record is there, my lord.
Okay, then
Page 32 is the my lord, relevant page of final report. Page 32.
is
33, my lord.
okay. Then
Then, my lord,
who filed this? Who is Madan Mohan Deka?
he is the son of the my lord, Ramesh Deka, original complainant, who is already died, my lord, expired. As a legal heir, he come before the court. My lord.
Now what happened here?
Here, my lord, he is my lord, prayed before the court that my lord, forgery has been done, and accordingly, my lord, the matter has been revived, and someone is issued. My lord.
Is there any mention of earlier proceeding in this case? No.
No. No, Lordship, here in this case, Lordship, this is the protest petition, Lordship. That protest petition was filed after submission of the FR by the investigating
Okay,
authority.
fine. Then what happened?
Then what happened, Lordship? Lordship, may I submit, Lordship?
Just a minute. What is the procedure
procedure is that, Lordship, after submission of the final form, Lordship, it is section 173 of Criminal Procedure Code, Lordship. If the police submitted FR, police had not find anything against the accused, Lordship, then the duty of the magistrate is that to send a notice to the
No, that
complainant.
is fine.
Yes.
There it's up to the thick, okay, the informant is legally is allowed to file a Naraji petition.
Lordship, Naraji
Fine.
petition filed.
Naraji is filed, then
Yes.
thereafter, what is the procedure?
Thereafter, procedure is that to carry a case as a private complaint. It's a CR case.
In all cases.
No, there is no.
What are the position and what are the conditions to continue with the CR case?
No, Lordship.
Tell us that.
Yes, Lordship. Lordship, when
suppose the magistrate is not satisfied that no
Lordship.
investigation was materials are there to proceed, then what will magistrate will do? What then magistrate will do?
He can send a notice to the complainant, and if the complainant submitted a Naraji petition, then the magistrate can run the case as a complaint petition, Lordship. That is the law.
Come prepared.
Lordship.
This is not the provision. We'll admit there is a stay.
Yes, ma'am.
Last occasion also you sought time to prepare.
No, Lordship, what happened, Lordship? This is not a separate case, Lordship. The 21.
That we understand.
Yes, Lordship.
This is a CR case. Assuming
Yes.
for a moment
Yes,
that this case, the Naraji petition is treated to be a CR case.
Then, Lordship,
but what are the conditions to take that course of action?
The magistrate should take the inquiry,
Admit.
Lordship.
Call for the record. As the parties are duly represented, no formal notice need be issued. Formal notice, however, formal notice need be issued. Full stop. The interim order passed earlier shall continue until further orders.
Date may be fixed, Lordship.
It will come.
Lordship.
In this matter, they filed a petition for vacation of interim order. I agree, that the matter may come up for admission, then the matter can be filed.
Yeah, in agreement, Your Lord.
Okay, the present application is filed under section 482 CRPC. Praying for quashment of proceeding being missed within bracket DV case number 91M/2023 pending in the court of learned JMFC Kamrup Metro. This court under its order dated 23/8/2023 passed an interim order staying further proceeding of the aforesaid case. Full stop. An application for modification of the aforesaid order is made by the respondents. Full stop. The learned counsel for the parties submits that the matter may be taken for final disposal as it involves DV proceeding instead of taking the IA at this stage. Full stop. Prayer is allowed. Please this matter. Next week, my lord.
After 1 week.
Give a date.
8.
On 8 of
8th of May.
11, 12, like that.
Yes.
When? 20. 28th of May 2024. Interim order passed earlier shall continue till then. If the matter is not taken for final disposal, the learned counsel for the applicant may press for the IA.
Yes. This is for quashment of the criminal proceeding. And that is pending now before the ADM at Hojai under section 145, 146. The LCR has not come. Now, I think, so whether it is possible for hearing or.
Lordship, I have filed for the vacating the stay order, Lordship.
Yes, they have filed.
Lordship, what even here in this case, Lordship, this quashing petition has been maintainable, Lordship. So annexer 4, 5, and 6, Lordship, is the tag documents annex, Lordship. False salary, Lordship.
Where is the order?
The order
Any order has been passed?
Yes, interim order is there, that is
Page 20,
page,
Lordship.
that order dated 11/9/23.
Page 20, Lordship, in my IA, Lordship. Relevant part, Lordship.
No, first thing, whether honorable court will hear the matter or not, then we will argue on merit.
What you want? You want to argue or not?
I am ready, from my side I am ready.
Okay, then you will.
But LCR is not here, that is one problem.
What kind of LC? What is the ground of your challenge? Tell us.
Because, my lord, we have purchased this plot of land in the year 1973.
Hmm.
By registered sale list. Registered sale list, my deceased father purchased the land. Since then we are in possession. 1973, it is 2024. Now, the other day, that is in the year 2023, they have filed this criminal proceeding under section 145, 146, and also got attachment order by swearing in false affidavit. So, the land which has been purchased in the year 1973, how 145 proceeding can go on? Because the time limit is 60 days only. If a person is dispossessed within 60 days, then only this proceeding would come. Now, we have purchased the land in the year 1973.
So you want to pass an order by High Court in exercise of its revisional power to decide that, to come to a conclusion that so and so has purchased a land by a registered sale deed and he is in possession, and therefore this is not maintenance. So we are doing the magistrate job. For that we will require some arrangement here.
No, because 145 proceeding.
Somebody says that I am in the plot of land
Since 1973.
in 1973. You are 73.
Yes.
You are 73. He says that we are in the land, we are paying tozi, this, what not, and we are continuing in the possession. You say, no, I am in possession.
They are not saying. They are saying that the land was put on us for financial difficulty. So for financial difficulty, adhyar. So adhyar does not mean financial.
Anyway,
benefit.
they say they are in possession by right of any
No,
by virtue
they-
of any right. Maybe tenant, maybe something.
No, they do not say. They say that we went to possess the land, but I have denied that if I will not allow you to take possession.
Lordship, let us see the sale deed, Lordship. So there is no need.
We cannot see the sale deed. That is the difficulty. We cannot see the
So
sale deed.
appended the such documents, Lordship, in the annexure 4.
And what and all there is civil suit now pending.
Civil suit pending.
Pending.
Who filed the civil suit?
I have filed.
The
Because
matter
they
ends
want-
here.
Is not
2%,
maintainable.
yes.
Huh?
Not maintainable, Lordship.
Which
Washington.
man maintainable?
The civil proceedings already pending, Lordship.
Who filed the civil suit proceeding?
I have filed the civil suit.
So go to the
because they-
civil court, that's all.
Yes,
We'll
absolutely.
close this whole entire proceeding.
Yes,
But
Lordship.
my possession should not be disturbed. Because I am in possession. she is
You have
also-
filed a suit, file and seek an injunction, that's all.
Yes, Lordship. Absolutely, Lordship.
Injunction petition is already there.
Already they are rejected or
Not, it is pending.
say that will be decided there.
Yes,
And the
Lordship.
timetable
Absolutely.
may be provided.
Hard. You should have said the first thing that this is a 148 proceeding. Already parties has approached the civil court. So that is to civil court is to determine who is in possession,
Lordship.
land belongs to whom.
Yes, that is true. But till
If
then,
that is true, that could have saved us 3 minutes of judicial time. Anyway, hard, Mr. Mahmood, learned counsel for the petitioner, and Mr. Swenso, learned counsel for the
Petition number 1.
Mm.
Respondent number 1, Lordship.
respondent number 1. The respondent number 1 instituted a proceeding under section 145 CRPC before the learned additional district magistrate. Isn't it?
Yes, Lordship.
Hojai,
Hosai, Lordship.
Sankardev Nagar. By in MR case number 66 of 2023.
Yes.
In respect of a plot of land measuring 8 bighas, 1 kathas, 9 lessas. Full stop. and also apprehended breach of peace and tranquility arising out of the dispute relating to the aforesaid plot of land. Full stop. The aforesaid proceeding is challenged in the present revision petition filed under section 482. Section 482 CRPC. Section 482 CRPC. Inasmuch as the subsequent order dated 10/6/2023 passed by the learned magistrate granting directing maintenance of
Allowing attachment of the
allowing attachment of the plot of land. Full stop. Mr. Mahmood, learned counsel for the petitioner, submits that in the meantime, the petitioner
purchased this land in the year 1973.
submits, Mr. Mahmood submits that they have purchased the land through registered sale deeds in 1970 since in the year 1971 and by sale deeds. We will not go to all this.
Yes.
We cannot. By different sale deeds, and they are in possession of the disputed land since then. Since then. On the other hand, the learned counsel for the respondent submits that they are in possession of the land and the present petitioners are obstructing, disturbing their possession.
They cannot say because in their pleading they have not said that
He has made a submission. Let me complete the dictation, Mr. Mahmood. I know these matters. Hold on. Full stop. It is however, Mr. Mahmood further submits that in the meantime, the petitioner has preferred a title suit being
TS number 52/2023.
52/2023 for declaration of their
Right
title interest and for permanent injunction. It is further submitted by Mr. Mahmood that an injunction petition is also pending for consideration. Full stop. Such position has not been disputed by the learned counsel for the respondent. In view of the aforesaid, the learned magistrate shall have no jurisdiction at this stage to continue with the further proceeding of under section 145, inasmuch as essentially the dispute relates to ownership and possession, relates to claim of ownership and possession over the disputed land. In view of the aforesaid, the present writ petition stands allowed by setting aside and quashing the MR case number 66 of 2023 under section 107, 145, 166 CRPC. Full stop. While parting with the record, it is made clear that the observation made in this petition shall not be treated as any comment on merit of either of the parties as regards their claim over the disputed land. Full stop.
It's a revision petition, not
Revision
petition.
Criminal petition stands disposed of.
Criminal
What is this? In view of the order passed in criminal petition, IS stands closed.
All right.
You the fight there, nothing is remaining.
Yes, okay. Yes.
Yes, Burwa.
Last occasion, my lord, I was supposed to place before your lordship for interim prayer, but respondent hurriedly took time, my lord, without any, my lord, reason, my lord, and took the adjournment. And thereby, I could not place my prayer for interim, my lord. Now today, may I pray for interim prayer, my lord. It was actually a case, my lord, which the respondent to, my lord, annoyed by the High Court writ petition order of Assam Mala Road project. They filed, my lord, as an ulterior motive. FIR was lost. Lordship will kindly come to page 10.
Yes,
is the
sir.
FIR.
You are repairing for whom?
For respondent number 2, Lordship.
Who is respondent number 2?
Principal Secretary.
Okay.
That is revenue. Now, earlier he was the revenue. Earlier he was the revenue.
Okay. What is the allegation against him?
Allegation only, my lord, house trespass.
Where is that?
Your lordship will find in the FIR page 10. Whereas it is an office, my lord. Purely, my lord, with ulterior motive. May I read it page 10, my lord? I would like to, FIR dated 27 June 23. I would like to inform you that on today, 27 June 2023 at about 11:30 a.m., see Dhiranjan Iding of so-and-so and Sodesh Zidung of so-and-so entered the office of Revenue Department, Dimahasa Autonomous Council, and started using slang language to the employees of Revenue Department, which include a majority of women employees. The mentioned person threatened the women employees and forced them to provide the service that is impossible to entertain.
What is the stage of investigation?
Well, already scan copy LCR has come. And, yes, I have also filed an additional affidavit. From the statement of witnesses, my lord.
We'll decide this matter on Monday, Lordship.
Only thing, my lord.
When is the next date? Is search sheet is filed?
Next date is on 3rd of May, my lord, on lower court for
3rd of
May, my lord.
We are taking it up on next Monday. What should be the next Monday? 6th. You take an adjournment, yes. Okay. 6th. You go through it and just have a sequence when what writ petition is filed, how it is done. Have a list of dates.
The IO has placed the seized document of writ petition Assam Mala, which we went to place there, but they are annoyed and they lost the FIR that don't come here.
Seat. Huh?
Lordship.
That is there, my lord.
Creating a havoc in the public premise.
No.
That is because of that only.
That's why we are not saying anything. We will see from the case record what is the material to proceed. We will not because a statement you have calculated, I will not say, you have made a statement that what they have done. But what is the record says? Then what is the scope of seizing us?
One contempt was filed against the respondent too. He is very annoyed. He is threatening the villagers, my lord. Don't
now also ongoing means litigation is there because of this Assam Mala, and now also the same petitioner is creating a video and publishing in the district, Lordship.
Maybe he want to expose you.
Lordship.
Who knows?
Lordship.
Who knows?
Lordship.
Okay, we'll take it up Monday.
Lordship.
Mr. Because tomorrow is a Thursday, na? Tomorrow day after we have fixed many matters. May not be possible.
In the meantime, we will file our objection. Okay.
What objection? We'll see the materials, that's all. We cannot go to anybody's until and unless some undisputed materials are there in a quashing petition. We'll see the case diary. Mr. Goswami, learned additional public prosecutor, submits that the scan copy, he may be allowed to go through the scan copies of LCR to assist this court. First stop. Prayer is allowed. List this matter on Monday. In the admission column. Yes. Gimana sir?
Please, Your Lordship.
Yes.
This is application file under 482 to directing the Honorable Court of Principal Judge Family Court to register the petition filed by petitioner under 127. What happened in this case that we had been given a judgment for 7,000 to the wife and 3,000 to the child. What then we prayed for, we applied for 127 petition to be given there to reconsider that order. So, but they disallowed, they didn't allow us to file this petition.
Where is your 127 application?
Annexure.
Annexure
8.
Page
49. There are certain changes in the circumstances also. The petitioner has accident on 17/7/2019 who is 40% locomotive disability. And there are annexure 5, 6 and 7 where
what was the earlier award?
Earlier award was in page number 37, annexure 4. We just want to file the 127. Let the court decide.
By the wife. By the wife.
No, husband.
By the husband. Manav Jyoti Das.
Yes. The court may later decide whether to.
Where is your statement that this was not registered? After filing, refused to register. Where is that statement? Who looks into this judicial? Register vigilance. Tolwa court of file policy department. Register vigilance. Call him at chamber. Yes. Where is your statement?
Just a minute, I have to check.
That is the most vital. If you have made a statement, we'll have an inquiry why this is not registered through the register vigilance. We want a statement that you went to file it, but it was refused.
Yeah.
And by whom, you say us.
By the principal judge too.
Where is that? Your word will not do, so that on that basis we can do something. Show us, go through it. Next case. Go through it and show us. Hearing will take a little bit later because we have some leftover matters. Okay, Mr. Singh, leftover matters. Then Mati ekbar break to le. Kuntu itu actually. Mati de ahi aso.
Wait, with your lordship.
Yes.
On last occasion, your lordship, it is my lord, item 12 is my lord postment of.
Yes,
FIR.
yes. What is your instruction?
Just file an affidavit.
Lordship, I filed an affidavit.
What is your stand?
I think like from the initial time,
Uh.
from the time of the seizure of the article.
Now, have you disposed it of?
Yes, yes. My lord.
Okay.
In the affidavit, it is submitted, but
Okay.
we have not annexed the record because it is during the case time.
Okay, anyway, you have
Yes.
taken an affidavit. When this affidavit is filed,
Yesterday, yesterday.
you will not file any reply?
Not necessary, my lord, because my lord, they have not asked about any whisper about the FSSI Act.
No, we'll go to that. What kind of relief it is disposed of? Now,
It should
what kind
dispose
of relief?
be disposed.
Because we want a deeper examination here. Whether the magistrate can in that way do a thing. If the magistrate has passed an order absolutely against illegally, then what course of action should he take? Okay. And second thing is that the so enthusiastic
Precisely, yes, my lord.
police officer, we want to meet him. We are sitting in this criminal bench, we are looking at what pace thing
Only matter-
goes and processes.
With due apology, my lord, only matter of for 10 lakhs. They have asked.
No, don't say all those things. Don't say all those things. We remain within your limit. If you want to have that, you file a complaint, we'll do.
Then later on, we'll have to.
Not later on, there is also provision. These
Yes, ma'am.
officers will have to do it in a specific period.
Only division bench have already filed my lord one.
So,
Police officers, yes. But my lord, the vehicle, two vehicles.
so
and
tell us,
two
so
mobiles.
what kind of relief will you get today?
Then my lord, they have.
Except final hearing.
Yes.
No,
Two
nothing can be
vehicles-
done.
Two
On
vehicles
that,
and two
had you
mobiles for
been
last 6
in
months.
the
my lord.
court on that day, we would have protected you, but already they have done it. And now the question will be whether they are,
Article dispose of one or two vehicles that is lying for idle for last 6 months.
is there anything or anything for Jimma also in this?
Yeah, already those vehicles were allowed to Zimma, but they are not, as per my
Why
instruction,
should
they
I
are
pay
not
50 lakhs around
going to take back.
50 lakhs for what?
for bank guarantee?
Now, who has passed this order? The magistrate?
Magistrate.
That will take note of.
Yes, my lord.
That will handle.
So my lord,
Now,
pay at this stage, my lord.
is it under challenge?
Yes, my lord.
The amount is not yet mentioned, my lord,
Item
only
11.
specifically
Item
stated
11, my lord.
on furnishing of a bank guarantee equal to the value of the vehicle.
Understand value of the bank guarantee. That will handle. Which petition?
11, my lord. Item number 11.
Item number 11.
Criminal revision, my lord. For Zimma of the vehicle and 2 mobiles, which will be, my lord, totally, my lord, it will be
Okay,
damaged
we'll
because
take
of
up
last
this
6
matter,
months.
we'll take up this matter a little bit later.
Yes,
Okay.
I would just like to point out one thing regarding that, my lord, Zimma of the vehicle, that matter is already disposed of. Regarding bank guarantee, my lord, they have not challenged regarding those, my lord.
Bank guarantee not
Not
challenged.
challenged, my lord. Now this is.
That order is not challenged.
Not challenged.
Order I have challenged. Why
Where
not
is that?
challenged? Criminal revision petition, my lord, at 161.
Yes.
That order I have challenged. That is the challenge, my lord. It is therefore prayed that your lordship receive it, please to all and mention appropriate.
Regarding the modification of that, my lord.
Modification of the order.
My lord,
My
bank
lord,
guarantee, that
because
is
Zimma
not.
will be given, but
mentioned
my
in
lord, not the bank guarantee.
Where is that?
Sorry, my lord, modify, set aside the order.
Okay, okay.
It is there, my lord.
We'll take it up.
Paragraph 17 and 18.
Hmm?
17, 18, I have challenged. Because
We'll flag those issues in
Yes,
this
sir.
petition today so that subsequently it can be determined. Because we do not think law will permit this. We may not be that somebody will come and say that, give me this, I will dispose it of. And magistrate, without hearing, course of what property will say, okay, dispose it of. Is that it?
My lord.
So smart police officer.
Absolutely, my lord.
What absolutely?
No, no, my lord.
We'll follow, we'll not release this matter from this court.
No, surely, my lord. It
Yes.
should be taken up in a matter,
Yes.
in a way. All the things have been done, my lord.
Where is the other matter regarding this release of imposition of bank guarantee?
this is there, my lord.
No, no, not
Order.
another matter we have fixed in these days. You wait for something, huh?
Okay, madam. After the break.
There are two matters, my lord, listed before your lordship, my lord, today.
On a beleg matter.
Yes.
There is another.
Okay, we'll come back. Give us 5 10. Friday. Huh? Friday, Pathan. Pathan police. We may take it up on Friday.
Yes.
Yes. Regarding Zimma, my lord, your lordship will say 6 months vehicle are lying idle. That will be
Madam,
damaged.
please argue substantively. Not on PT. The Act subsection 5 of section 11 says that bank guarantee. Now under 482 to what extent or whether that is mandatory or discretionary. And how to interpret that. Argue on that, don't argue on that I am having this. Determination is to be done under the Act,
Yes.
FSSI. Is not it?
Yes.
Until and unless you make a determination, how will you have a conclusion that it is a beef or a goat
Buffalo.
meat or any other
Any
meat?
other.
That being the position, the magistrate, even if assumes that can impose a bank guarantee, where is the satisfaction? That there is a prima facie case. Prima facie case of a violation will come on basis of all this, that this is an illegal meat under cattle prevention. This is not a cattle, that live cattle. These are seized meat. Now, how it is the determination is to be made? The magistrate says dispose it of. Where is the determination that this meat is a beef meat? Who will compensate? Police officer or a magistrate? As simple as that. That is your argument.
Absolutely correct.
And determination is given how to be made under that FSI Act, because under that Act only the determination can be made, not under cattle prevention. And assuming for a moment that in cattle prevention there are some provisions,
Yes.
where those provisions are followed. So eager to dispose of the meat. Isn't it? List
Followed as part.
hard at some length. List it for further hearing on Friday.
On Friday, I will point out everything.
You point it out that there is no requirement. When we say that this is to be a meat not permitted, it is not permitted.
Yes.
No further investigation is
Yes.
required.
Yes.
Then we will dismiss this petition.
Yes. I
That
will
no
point-
further investigation is required. You are the absolute authority
Yes.
to determine that whatever we say is correct.
Yes, I will point out.
Yes.
Yes.
If that is so, then we will dismiss this petition.
Yes,
And if there is any rule of law,
yes, sir.
any determination need to be made, then we may think of imposing cost upon this man.
Yes. I will point out, my lord, everything, my lord.
Yes. That's why we are giving a time. See, basic thing is that we are not saying, commenting anything on your power.
Yes, sir.
You are having the power of search and seizure for disposal, everything you are having.
Yes.
No doubt that we cannot say that you will not be able to dispose of this seized material.
Yes.
You are having the power.
Yes.
But having power is one thing,
Yes,
and
sir.
exercise of its power is other thing. That is why that rule and laws are there. That's all. Yes, next case. On Friday, along with so and so, so and so. Item number? Yes, Ahmed, what is this?
There is a bail application, Lordship. Final complaint, your Lordship will find page.
Where is the
That, they
NCB?
came. After this matter, they came, Lordship. When first this matter was called, after that, the junior came and she verified the records also.
Wait for some time. We'll pass an order, maybe adverse. We'll make a comment. We'll call for the ASG. Yes, next.
In this case, I have gone through the LCR, but to show that his house search was made on all this, he is not an absconder. CD is required. Only the face has been come, CD part not can. But here, in the CD itself, this is a case of 326. Injury report is there. Statement of the complainant is there. As per the injury report, 2 persons, one is grievous by sharp object. There is 2 cut injury, and another person is, she is also grievous, lady, by hard object. There are 2 brothers, who 2 accused, one arrested on the same day, my lord, and he is the brother, he is absconding on the same day itself. From their house, seizure list is there, 2 big dao and lathi iron rod were recovered. That is the seizure. Now, his case is that he is still there, but he has been shown as absconder. But to show that,
my submission, my response submission is that, my lord,
yes,
I am seeking protection, my lord. And in the event of the learned committal court choosing him to remain in custody on his appearance, responding to the summoning order dated 8/12/2023, my lord. So as the police is concerned, police has no, you also know, police has no power to declare me absconder. Page 20, my lord, it is clearly absconder. Now, without making any, my lord, without making any effort to arrest, to interrogate, or trace me out, my lord, simply declare me absconder, my lord.
That is what we want to see. That whether that was your house was searched, any attempt was made. If nothing was done, then you are protected. We are passing orders every day. And if your house were searched, even if we will not go by his statement that what do you mean by your house is searched, then your that alleged things were recovered.
From the house.
So we want to see whether specific there is something on the case diary that attempts were made and on such sense as these are because on earlier occasions we have seen in some cases where there are specific that so and so's house is arrested in presence of these witnesses, but he could not 1 day, 2 days, 3 days. And in some other cases, what we have seen is that there is no attempt, simply that you have said simply absconder. It cannot be. That law we are aware, but law is one thing and the ascertainment of fact is other thing, isn't it? Law will be applicable in the given facts of the case. So law we are aware that what should be the procedure.
So far the Amanpreet Singh is concerned, my lord, Supreme Court judgment, it is saying if he was not arrested in a non-bailable cases, he was not required during the course of investigation, my lord.
Then if that be the principle of law, then there will be you abscond and you give you a bail.
No, my lord. I'm not as well. We are ready now. We are ready to face trial, my lord. summon issued.
That is what I'm saying. You are ready to face trial.
Because my
Suppose, just answer this question. There are materials in the case diary that you inflicted the hurt or injury and the weapon used in the commission of crime is recovered from your house. Okay, just listen to me. This is the material. Suppose we take your case, material in your case. Then it is also seen that your house was searched. You could not be traced out. Your brother was arrested. Now search sheet is filed. And you were absconding or you could not be arrested. Now, in this background, given facts, can we pass an order saying that since he could not be arrested during the investigation, so don't arrest him? Is it law?
no, but it is no same, my lord. So my
So it will depend upon given facts, or in certain cases we may see what is the purpose. Then we'll give you, it will amount to giving a license. Yes, of course, you are correct. That what is the purpose to be filled now if you are put behind bar? But that will be not our lookout. Then it will be a license to everybody.
my submission is has already submitted. Every investigation completed. What is there in the case diary? We will decide it as the trial proceed, my lord. The credibility of
So
the
therefore, that is my question.
Yes, my lord. Yes,
That these are the materials
Yes, my
against
lord.
you. You killed a person, you were absconding. All materials are there. Since you were absconding, you need not be, you will be protected because now search sheet is filed. Is it law?
Credibility of the evidence coming to light in future, and that cannot be ruled out, my lord. But at this stage, my lord, I will be allowed to, my lord, my lord, face trial, my lord, my lord, during the course of trial, my lord. Every day, my lord, I will attend Learned Court will as the date fixed, my lord. Because on the moment I appear before the Learned Committal Court, will put me behind the bar, my lord. This is my only apprehension, my lord.
The legislature will have to do something in this regard.
Because my lord, I'm more pressing.
Two, case record of PRC case number 1037/2023 is scan copies is received by the registry. However, the case diary pertaining to
my lord, Lord North Lakhimpur,
PS case number 644/2022 under section 294/326/307/34 IPC, which is part of the aforesaid case record, is not received. Accordingly, registry to call the aforesaid case, scan copies of the aforesaid case diaries and list this matter on given date. 29th of left over, nothing. Yes.
Case there was call for action.
Case
there was call for action.
Yes.
If I receive lordship,
Any interim?
no lordship. Here lordship.
What is the FR?
Page 11 also. Type 4.
What is your name? This
Atikul Islam.
Yes, injury.
Yes, lordship. Here, if lordship comes to page 19, the subordinate court lordship rejected the prayer of the petitioner lordship and also observed about the injury lordship. Page 19, last paragraph lordship, kindly says. Last paragraph lordship. Atikul Islam gave him blow on the head with a conti.
That is there in the case.
Yes, yes. And injury is reflected in the second page lordship, page 20 lordship, first paragraph. Injured Fajordin sustained craniocerebral injury.
Okay.
Craniocerebral injury with soft tissue injury. Following that is also from the medical report. He also suffered fracture on the top part of the skull, lordship. That is also here, lordship.
Lordship, the FIR says it was a down, but
we cannot decide here now.
Witnesses are also there, lordship. stating the same thing, Lordship.
A paragraph লিখে দিব 19. Page 3, page it. Consider them, peruse the statements of the witnesses and the injury report. From the aforesaid, it is found that it page 19, pencil mark. Dismissed. Yes.
No.
Okay, we'll allow this petition.
I'm relying some judgment.
Yes.
Lordship, and-
Give those judgments, very important. And you note.
And give the paragraph also, man.
Yes, very good. That's why we need you.
My lord, we will in judgments will refer
All
the
these
paragraph.
things write down on my hand.
That will accept. Okay. Okay. And who had heard MS?
S.G. Borua.
S.G. Borua, learned counsel for the petitioner. Mr. N.N.B. Chaudhuri, learned additional advocate general for the state of Arunachal Pradesh. Mr. For Sandran, for whom?
For municipality.
Respondent number?
6.
Respondent number 6. State of Assam. State of Assam. And P for correspondent number 8 and item 31. Okay, dispose of.
My lord,
Can we fix a date for appearance before? For you, no problem. We'll give a date, just go through to this. We'll have a when it's available and not dispose of it. Monday we'll get this one.
judgments will write the relevant paragraphs. My lord.
Or you can mark it also.
My lord.
Mark it and give it to you.
My lord.
Mark it.
My lord, one judgment I have given the separate law with regard to this. The other judgment with regard to the power of this court in writ of Chachuri with regard to that.
That is
That aspect I have given.
just mark the either
When
underline.
it cannot be exercised, but it can be exercised, that part I have given.
Yes.
One section is disturbing, my lord.
Which
That
one?
report is got finality. Otherwise, everything is our paper.
Hmm.
49-2, my lord. That is disturbing.
one
It's got
more-
finality, my lord.
My, and with regard.
But finality will not be finality. Prima facie
Yes,
find
sir.
that it's a fraud. Fraud
Yes, sir.
vitiates everything.
Yes, everything is
That is
vitiated.
there.
We'll see that, and we may not go to that extent because of their cooperation.
Yes, sir.
That is another way. That is what I'm thinking. That's why it will require some time to dictate.
Yes, sir.
So, this is.
We'll
I
keep it
prefer-
dispose of for delivery of order on Monday. Dispose of. Huh? Huh? For delivery of order. Hard hearing concluded for delivery of order on Tuesday. Okay.
Because also-
Anything we may require some clarification on that day.
My.
Okay.
My.
Just mark this.
Mark this. My lord, because prior ossification along with radiological also. My lord.
We have okay. We'll pass delivered order on that day.
My lord.
Yes.
Lordship, the para 11, page 10, you ask for. the
Para 11,
Page 10.
page 10.
Next up, man.
Tuesday.
And then
You don't want to vote or what? Item, paragraph?
11, page 10.
Page 10. Paragraph 11. Please.
We first approached the office of the family court 2, then they told us that it will be done registered in court. Then
Okay,
approached
we are not passing any order right now. We'll take in the administrative side what is actually happening, then we'll proceed. Okay, let us see. Itu rakhi thabo samajh. না হেৰিটো মাতা সেইটোতো হিয়াৰিং হ'ব NDPS টো মাতা অংশমানটো সেই দুটাই বাকি আছে
50.
47 কিয় আছে হা we'll call this matter first a record to the yes Mr. Bora.
Also, can you take up my IA, my lord?
IA. Yes.
Page 56, my lord.
Page 56. Yes.
This is the FIR, my lord.
All the important things are annexed here, or we'll have to go to record. Not necessary.
Only one document lordship has to go to record. The DD entry I have not annexed.
Okay.
Rest of the things lordship can find it here. It's lordship kindly see the date of the FIR is
9/5/2022.
Yes, ma'am. The time period is 10:30 PM.
Okay.
Page 64 is the FIR, my lord.
57.
57.
Yes.
This is to inform you that on 8/5/2022 at about 10:30 PM, an information has been received by me from reliable source that a large quantity of the drugs, heroin, is transporting from Dimapur from Assam, National 36. They immediately informed the Deputy Superintendent of Police Headquarters, Difu, and the general diary entry was made by me by Delay PA GD entry number 162. Lord, you kindly mark it. The GD entry is 162, dated 8/5/2022. According to Inspector UB Mobik Brahma, OC Bukajan PS self, along with the SI UB Raj.
What was the time of this GD entry?
GD entry, GD entry, the time is 10:30. Now, what you kindly see in the FIR, GD entry to go to self. Yes, 56, my lord. Column 3. General diary
page,
reference,
page
entry
50.
number.
6 lot, page 56.
हाँ 162.
Page 56, my lord.
56. Okay.
General diary reference, my lord.
In column number
3C.
3C.
General diary reference.
174.
170. Now, date is also, my lord, 9/5. Time
9:15.
9:15.
Date 8/5.
8/5.
Occurrence of offense.
Date of occurrence. Information received is 9. Information received at PS is 9/5. General diary reference is 174, dated 9:15 AM. This general diary not been exhibited. This general diary, if there is any general diary,
This general diary is of 9/5.
this number 174.
174 is 9/5.
9/5, that's not been exhibited. Nor in the record. Just logic kindly mark it.
Okay.
All along, we'll find in the here only one GD entry and which has been exhibited, that is 162, dated 8/5/2022. That is exhibit P3.
One 62 is 8/5.
8/5. That is the secret information reduced into writing.
Okay.
And that is exhibited at P3 by PW4. Now, Lordship, kindly come back to page 57. FIR. The Delay PA GD entry number 162 dated 8/5/2010. Accordingly, Inspector so-and-so, 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 so-and-so. Assist. Then Bisra, Robi Gill, Assistant Commandant 20 BN with 1 section CRPS BN Personnel Commander Swen Bogajan reported at PS, and accordingly Naka was set up jointly at National Highway 36 to nearby Delay Police Station. I also informed to the local government.
Just let me note it down. According to prosecution,
yes,
from their exhibit,
yes,
on
8,
they have
received
2020-22.
Yes.
Received secret information, and accordingly GD entry
was made.
162 made, which is exhibit P3.
Yes.
Okay.
By PW4.
By PW4. Then they got authorization.
No authorization.
No, they said that.
They said it.
They said it.
They
No,
said
we
it.
are saying their story.
Yes.
They
They have
said
said they have got the
authorization since it is night.
Yes.
So authorization, and they proceeded.
Yes.
Now, on the same date, or
Yes.
that is on 9
itself,
11:30 says it's what you call it 9.
On night, they have lost the FIR.
Again, 9/5, there is a first reference of GD entry 164, 174.
Yes.
174 at 9:15 AM.
Yes.
Okay.
Yes.
9:15 AM. Now on 9/5, 11:30 PM recovery.
8-5.
No, 8-5 recovered.
8-5 recovered. 8-5 recovered.
7:30 PM.
So admittedly, my lord, it was after the sunset. There is no dispute about
No
it.
dispute about it.
Now, as per this FIR, my lord, they have proceeded, they have to the NACA checking as the information was received after the sunset at 10:30 PM. So likely operation as entry, search, seizure, arrest would probably be before sunrise. So a written authorization was issued to me by Mr. Nahid Karishma, APS, Deputy Superintendent of Police, Karbi Along Depot, which was entered in the Delhi PA GD entry number 162 dated 8/5/2022, who is empowered by the government of Assam, notification so under section 41 of the under NDPS Act, such is authorization. So as per their case, so he has been authorized by a Nahid Karishma, APS, Deputy Superintendent of Police, Karbi Along, and which has been entered in the GD entry under 162. That is their case. Now, in the whole case, there is no authorization been exhibited.
Anything under GD?
Now, Lordship, kindly see if I have the copy. Radio record. Lordship, kindly record.
GD entry 162.
Yes.
162.
Now, 162, my lord, this is exhibited, my lord. Etia গোপন সূত্ৰে ইমানৰ পৰা ইমানলৈ এখন মণিপুৰৰ পৰা গুৱাহাটীলৈ এখন চাৰিচকীয়া বাহনত কোনো দুষ্কৃতিকাৰীয়ে কিছুমান নিচাজাতীয় ড্ৰাগছ হিৰোইন কঢ়িয়াই আনি আছে সংবাদ মতে পাই মাননীয় ডিএসপি কাৰ্বি আলং মহোদয়ক ইন্সপেক্টৰ ব্ৰহ্মক পিএছ ইমান খাটনি আৰু পিএছ ফোন যোগে অৱগত কৰি মই এছআই লুৎফুৰ ৰহমান ওচি ধিলাই পিএছ জয়ন্ত বৰা সংগী সহ এই থানাৰ অন্তৰ্গত 22 মাইলত নাকা তালাচী কৰিবৰ বাবে ৰাওনা হলো। That's all. So, as per GD entry, there is no authorization. Neither there is an exhibit regarding the authorization, neither in the GD entry there is a whisper about the authorization.
Yes.
On the same day, about 11:15 PM, one black color Ciaz car without registration number having chassis number so-and-so coming from Dimapur side was intercepted and checked in the presence of the local
Are
witness.
these intentional?
I will give the reply.
No, just, is it a way? Okay, you may have a legal submission on that, but you cannot improve the GD entry.
No.
There may be legal entry. Legal explanation you might have, we'll not go into that, but is it a way to record such a huge record? You have information, everything. Anyway, we'll come it later. Yes. Yes.
Along with the Assam Night census, Ali Division, Assam Mrs. Nahid Karishma SP DSP Dipu was also turned up at PO on through search and car and the body of the driver along with his accompanied in the car, complying the provisions of 165 CRPC and 50 NDPS Act, recovered 152 number of the shop boxes of suspected heroin from the. Now, Lordship, can you say recovered 152 number of shop boxes of suspected heroin from the dicky of the said car which was kept concealed in the two numbers of rice bag, one bag club polythene, sealed with the khaki colored adhesive tape. According to driver name is so-and-so, 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 these are the petitioner. Village so-and-so, so-and-so, Senapati, Manipur, and other so-and-so, so-and-so, David, so-and-so, so-and-so. Senapati were apprehended. The apprehended person revealed during the spot interrogation, they carried out the identical heroin from the Manipur, which were procured from the Myanmar. Further, they are involved in the transportation, import, and export from India. Psychotropic substance as disclosed by the apprehended person as learned from the reliable sources. International gangs are financially directed indirectly three kinds of illicit traffic drugs and the psychotropic substance into the India, Myanmar, etc. Suspected heroin recovered from the state car was subjected to the filed test weight with the polythene packet without containing the soft boxes in presence of the above named witnesses. Lordship kindly mark it. Superintendent Depot Inspector Mobik Brahmo.
Suspected person recovered from the said suspected filed with test with in presence of evidence, Deputy Senior Police.
Presence of witnesses, Deputy Superintendent Police Depot and Inspector Mobik Brahmo, OC Bukajan. The net quantity is so-and-so grams suspected to be found heroin, weight is so-and-so, so-and-so, seizure memo following the law and in the presence of the two independent witnesses mentioned above. Also says the following item in presence of the independent witness seizure memo. One black color CS card, 152 number soft boxes containing suspected heroin. Then the Aadhaar card, manual book, HDFC Bank, opposite mobile, Vivo, these are not important. Seized suspected heroin is packed and sealed. In this spot, in presence of the independent witnesses and accompanying our formalities, police party departed the place of occurrence at 1:45 a.m. Lordship kindly mark it, 1:45 a.m.
Where is that? Says, huh?
That is on page
58.
58, my lord. Last portion, my lord. This is suspected heroin.
It says suspected heroin, yes.
Yes. Packed and sealed in presence of the independent witnesses after completing the all formalities. This police party departed from the place of occurrence at 1:45 a.m. on 9/5/2022 to the Delhi police along with the seized item with the apprehended person. We may be mentioned being the sub-inspector. I am empowered by the government of Assam by notification under the provisions of 42(1) of the NDPS Act, enter such seizure without any authorization.
Okay.
Now, seizure.
Seizure is
page 59. Type copy is the seizure. Now, Lordship, kindly see, this is very important, page 64. These are the seizure
64.
And 60. It was, now, page 63 also, Lordship can mark it.
Page 63.
63.
Yes.
This is the inventory. Now, in the bottom, Lordship will find there is a signature of a magistrate which has been not been exhibited. Just for Lordship. Perusal. This is the inventory. No date.
This is exhibit.
Exhibit, my lord. Inventory exhibit. P25. Exhibited by PW 6.
Okay.
Now, this inventory, seizing officer is the Lutfur Rahman, SI my lord, so and so, so and so. Now, Lordship kindly see narcotic drug, psychotic substance, first column, total 152. Stop boxes containing the plastic pouch filed with a brown color powdered substance suspected to be heroin. Pill test found positive of the heroin. Total weight so and so. Then in this quantity, then the quality, mode of package. Soft boxes containing heroin are packed in one cartoon box and packed with the mark, cloth, stitch and seal. Then mark and the number. Soft boxes plastic purchase are marked by the sealing officer 1 to 152. Then other identity, soft boxes are containing the heroin and packed in one carton box and packed with the marking cloths by the stitch and seal. So this is the inventory they have prepared. Now, inventory does not say about the sampling before the magistrate. This is just an inventory which is accordingly them. There is a signature of the magistrate, but there is no to that effect that the sampling has been prepared. There is no whisper. Now, this is a certificate in the appended in the last portion, Lordship will find before the signature of the magistrate, my lord. There is no name, only there is a stamp, appears to be stamp of a magistrate. That magistrate not examined, neither this particular signature been exhibited.
Yes.
Now, page 64, my lord. This is the forensic report, my lord. Date is very important, my lord. This is 14/7.
This is exhibit C, is not it? Exhibit 6, exhibit P25, is not it? Inventory.
Inventory is page 25.
P25 by PW6.
Now, next page, my lord. 64, page 64, my lord. That is the forensic report. Now, this is very important, my lord. Document. Now, this is exhibit P10. Find here with a report
Exhibited by this officer.
PW5.
Yes.
Please find here with an enclosed report. DFS so and so number so and so. In connection with the DLIPS number 12, 22 under section 21C so and so. After received by your memo dated so and so, dated 12/5/22 by special messenger. Please acknowledge the receipt. Now, they have received this contraband on 12/5.
Yes.
Now, the contraband was seized on
8/5.
8/5. And it was forwarded to the FSL for forensic examination, that is on 12/5.
Yes.
Now, next line, my lord, the exhibits are returned herewith. Now, this is also very lordship, can you mark? The exhibits are returned herewith from all future correspondents. Summon the report number, please, reported so Abhijit Gogoi, scientific officer, drugs and future. Okay. So, from this exhibit P5, it's apparent that the contraband they have received on 12/5 to a special messenger. So, 9, 10, and 11, the 3 dates. These are very crucial dates for me.
Yes.
Next. Then the report, my lord, it's not important, my lord. We have not. Now, from the report, lordship will find
page
only one thing, page 65, the description of article.
This is exhibited as
P9
by PW5.
P9 by PW5.
Now, description of article, that's important, my lord. "15 number of seal envelopes."
Just a minute.
15 number of seal envelope marked as so and so. A to 15, sample A, each having closed polythene packet containing so and so gram brown colored powdered substance, respectively marked as D and so number. So accordingly, they have received 15 number of envelope marked as sample so and so.
Yes.
Now page 66, man. PW1, man.
Page 66.
Page 66. Oh, no. He is the independent seizure witness. I know the complainant Sub-Inspector Lutfur Rahman. Today I have identified both the accused person, namely so-and-so, produced from the jail hazard through the video conferencing. Occurrence took place on 9/5/2022 at Delhi, 12 mile after 11 p.m. On day of occurrence, there was a police checking at Delhi at 6 mile. After 11 p.m., one black color car was coming from the Dimapur side towards the Delhi side without registration number. Police signaled to stop the car. Accordingly, the car stopped at Delhi 6 mile. Police personnel searched the car and recovered 152 numbers of soft cases. 152 number of soft cases from the dicky of the car, which were kept concealed in the 2 numbers of rice bags. There were 2 passengers, including the driver in the car, whom today I have identified in the car through the video conferencing. During the time of the search, officer in charge, Delhi Police Station, SI Lutfur Rahman, officer in charge, Bokajan PS so-and-so, Dipu, along with the police personnel were present at the place of occurrence. Police weightedly recovered the suspected drug in presence of me and found total number of 2 kg. Police prepared a weighing list in the presence of the witness, and I put my signature on the weighing list, so is my signature. Later, police seized the recovered 152 number of the police plastic shop cases. In each shop cases, suspected drug was kept in a small polythene packet, which total weight was about 2 kg. Police also seized some document from the possession of the accused person. Exhibit 2 to 1 is the seizure list, is my signature. Today, I have seen the seized 152 number of shop cases. Now, this is very important, Lordship. Kindly mark it. This is very important.
Page 68.
68. First line.
Today I have seen.
Today I have seen seized 152 number of shop cases in court. Material object number MO1 is the seized 152 number of the shop cases.
So you want to say only shop cases?
Of shop cases. Okay.
Yes.
Cross examine, my house is so and so delight. I am in the auto driver. I am driving the auto rickshaw since 2 last numbers. I did not remember the registration number of 2 auto rickshaw. Occurrence took place at 11 time. I was returning the Dimapur during the passenger. I went to the home to 19 Dimapur along with the police waited. This is not very important, madam. And only thing, only I have a good relationship with the police personnel. That is in the cross examination. Only one part. That is, Lordship can mark it. Though he is claimed to be the independent witnesses, but his cross-examination, he said he has a good relation with the police. Now PW2, madam. The another independent witness, madam. I know the complainant says so and so. I am
PW2.
Independent witness.
Next page.
Next page, madam. Page 70.
Just a minute. Huh? Yes.
I know the complainant SI Lutfur Rahman. I am the Nayak of VDP party Dilai area. Today I have not recognized the accused person produced from the jail hazard through the video conference. The occurrence took place on 8/5/2022 error. Now his date is 8/5. PW1 says 9/5. He says 8/5/2022 at about 11 p.m. at 12 mile. At that time, the police apprehended one vehicle at 12 mile Dilai. There are 2 persons inside the vehicle. Police searched the vehicle, recovered the 152 numbers of drugs packets from the inside the vehicle. After recovery, police weighted the drugs packets from the so-and-so, but I do not remember total weight of the so-and-so, 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 exhibit so-and-so, so-and-so is my signature. These are the exhibits, my lord. Regarding weight on the seizure. Then police prepared a seizure list. I put my signature in the seizure list. Exhibit P2, P1 is the seizure list. Cross, I used to be a VDP party duty from 9 p.m. to 12 midnight guarding the village. I have an identity card VDP party. This is not very important. Now, last part is important, my lord, page 72. As police called me to come to the place of occurrence, hence I went to the place of occurrence. I know PW1 Abdul Ali, but Abdul Ali was not present along with me. So, PW2 disputed the presence of PW1.
Same seizure they have exhibited,
Yes.
isn't it?
Now, next line is very, except NDPS cases, police made me witnesses in other cases also. So he's a regular witness for the police, madam. So whether these both can be treated as an independent witness, madam. Now PW3.
Just a minute.
PW3.
PW?
3.
3.
She is the DSP Nahid Karishma. DSP, my lord. I know the complainant Lutfur Rahman. Today I have recognized the accused person, namely so-and-so, produced from jail hazard through video conferencing. The occurrence took place on 8/5/2022. Again on 8/5/2022. So you can mark it again. It can be 8/5. At delay about 11:15 p.m. Because seizure was made, the car was intercepted at after 11. So it has to be 9. On 8, they have received the GD entry, received the secret information. On 8. Accordingly, they have proceeded, but accordingly, on 9, they have intercepted as per the other witnesses.
On 8/11:15 p.m.
Yes. Some of the witnesses say that
on 8/11:15.
Yes, 11. Some of the witnesses say that is 9.
One PW6 says 9/5.
9.
And PW2 says PW2 and PW3 says 8/5.
8/5. On day of occurrence around 10:30 p.m., officer in charge of the Delhi police station, Lutfur, informed me about the large quantity of the drug were transporting from the Dimapur, Assam to so. I directed the officer in charge of the Delhi police station, Lutfur Ramta, to set a Naka checking Delhi. I proceeded to the 12-mile Delhi and reached the place about 11 p.m. At Naka checking point, 12-mile, Delhi officer in charge of the so. Bukazan police CRPF person, Assam person are detained at the 6-mile at checking. At 11:15 p.m., one black color CS car without registration number coming from Dimapur side towards the Manja side was signaled to stop at 12-mile Delhi. According to black color CR, stop at 12-mile Delhi. Naka checking point. A thorough search of the seizure car was recovered. 152 numbers of the plastic shop boxes from the dicky of the CR's car were kept concealed in 2 numbers of the rice bag and 1 black color polythene sealed with the packet of khaki color tape. In presence of the independent witness, the shop boxes were containing suspected heroin. There are 2 persons in the CS case named driver so. Name of the other person is so. Both persons were apprehended by our staff. Recovered suspected heroin and fell tested at the place of occurrence found positive to be heroin. The recovered suspected heroin were weighed in the presence of me, Inspector so, Brahman and Lutfur Rahman. At the place of occurrence found total weight is so. Exhibit so is a signature in the as a gazetted officer. Later, the complainant Lutfur Rahman, officer in charge of the Delhi police station, seized the recovered 152 numbers of the packet, suspected to be the identical heroin containing the total number of so, 1 black color CS without registration number, Aadhaar card, 1 so, handed the prepared seizure list. I put my signature in the seizure list, gazetted officer so. Cross examination. So, admittedly, my lord, PW3, she was absolutely silent about the contraband in the court. No identification. Now cross-examination part, my lord, page 76, my lord. When SI Lutfur Rahman called me, I was at patrolling duty near Manja. At around 10:30 p.m., SI Lutfur Rahman called me. I reached at the place of occurrence at 10 p.m. I have authorized later SI. I gave authorized later. This is important, my lord. I gave authorization later to SI Lutfur Rahman to search and seize. This was not exhibited. There is no whisper, nothing, no such document present, man. This authorization, man. As I Lutfur Rahman entered inside the Sia's car, I did not enter inside the Sia's car. At the time, there was two independent witnesses available at the place of occurrence, but I do not remember their names. The body of the accused person was searched in presence of the independent witnesses. Nothing was recovered from the below the cyber seat and the present seat. Suspected heroin was recovered from the dicky of the Sia's car. The weight so-and-so packet I could not say the weight suspected, but it was mentioned in the weighing list. The recovered heroin were packed and sealed in a carton in the place of occurrence, and after this signing of the independent witnesses and including me, the carton was taken to the Delhi police station by officer in charge of the Delhi police station, Lordship kindly mark it. Now, this is Lordship very, very important aspect.
Yes.
The officer in charge of the Delhi police station, SI Lutfur Rahman, recorded my statement under section 161 CRPC. It is a fact that I did not state in my statement the name of the driver was so-and-so, so-and-so, so-and-so. I could not say specifically from whose possession the seized heroin was recovered, but it was recovered from both the accused person. It is not a fact that I did put my signature in the presence in the sealed carton. I was present in the place of occurrence till 1:30 a.m. of 9/5/2022. It is not a fact that today I have deposed falsely in so-and-so. So from her statement, it is the page 67, last paragraph, says 76, my lord, last paragraph.
Yes. Officer in charge.
No, the last paragraph, the recovered heroin was packed, sealed in cartoon at the place of occurrence, and after signing of the independent witness, including me, cartoon was taken to the Delhi police station by the officer in charge of the Delhi police station. So it was sealed in the place of occurrence. Then it is taken to the police station.
Yes.
Now, Lordship kindly mark it was sealed at the place of occurrence in a cartoon. Everybody put their signature, taken to the police station. PW4. Now he is the seizing officer, Lutfur Rahman. On 8/5/2022, I was posted at Delhi police station as the officer in charge. On the day at 10:30 p.m., I received the secret information that huge quantity of drugs were transporting from Dimapur to Assam.
PW3 is DSP.
Yes, DSP. 4 is the seizing officer. Sub-Inspector, my lord. I received the secret information that huge quantity of drug was transported from Dimapur to Assam through National Highway 36. Then I immediately informed the member to Deputy SP Difu. I made a general diary entry, Delhi PS GD entry, dated 162, dated 8/5/22, so exhibit in the extract copy of the GD entry dated so exhibit P3 by PW4 is my signature. I also informed the matter to the inspectors Mobik Brahma, officer in charge of the Bukazan police station, Raju Dwara, officer in charge of the Khatkati police station. I immediately went towards the 6-mile Naka checking point along with my staff. I also informed the matter of local Gaunbura and the VDP members and requested them to come to the Naka checking point. Inspector Mobik Brahma, officer in charge of the Bukazan police station, Raju Dwara, officer in charge of the Khatkati police station, SI Biplab Das, Bukazan police station, HG Jayanto Bora, Lank Nayak Nanda Rangong, Sikari Inti, Hamnath Chetri, Dipankar Pator, Jackson Khachari, Bishnu Lambu, Sri Robi Gill, Assistant Commandant, 20th Battalion, so-and-so. One section arrived in 6-mile Naka checking point along with the DSP SP Dipu Simoti Nahid Karishma APS as the information was received after sunset 10:30 p.m. So rightly operation was entry and search, seizure, arrest, etc. could probably be before sunrise also. A written authorization again, my lord. a written authorization issued to me by Srimati Nahis Karishma, Deputy SP. To that effect, the GD entry, Lordship has already seen. The GD entry is absolutely silent regarding this authorization. Neither, no exhibit, nor there any kind of authorization been exhibited. Who is empowered by this government Assam to issue such authorization. Now, page 80. On the same day, about 11:30 p.m., one black color CS car without registration number coming from the Dimapur side towards the Delhi police station intercepted and checked in the presence of the local witness, namely so. During thorough search of the car, the body of the driver along with the accompanied car under provisions on so in presence of the so 152 numbers of the shop boxes containing the suspected heroin wrapped in a small polythene packet in each shop box from the dicky of the car, which escaped concealed in the 2 numbers of the rice bag in the black color polythene sealed with the khaki colored tag. At the time, there was 2 persons inside the car. On asking the driver of the car, identify himself as the so-and-so. Identify answered so-and-so, whom today I have identified, produced from the jail hazard through the video conference. On spot interrogation, accused person said that they carried the suspected heroin from Manipur, which were produced from Manipur. Further, they stated they were involved in the transportation, import, and so. As disclosed by the apprehended person, as they learned from the reliable sources, international gangsters financially, directly or indirectly in this kind of illicit traffic, drug, and psychotropic into India from the Myanmar. The recovered suspected heroin was filed. Field test was Srimati Nahid Thana APS, Dipu found positive for heroin. The recovered suspected heroin was weight so grams suspected, we are not disputing. I see the one black color CS card, 152 number of soft boxes containing the suspected identical heroin waiting number so, one other card. These are the important. So these are the seizure lists. Accused person put their signature in the seizure list along with the independent witnesses, gazetted officer P. Nahid so is the exhibit so. Then I drew a sketch map of the place of occurrence so. Then I recorded the statement of the seizure witness along with the interrogated. I interrogated the person, recovered the statement and place of occurrence. I also recorded the statement of the Nahid so. I also took the videograph of the incident with the help of the computer operator so. I issued a certificate under 65B of the Evidence Act by the certificate issued by the so 65 in the signature which I know. Later I seized the videography CD from the, now Lordship kindly see, this is important. Later I seized the videography CD from H.G. Shankar Chetri. Today I have seen the videography CD in the court. The material object number MO1 is the videography CD. Exhibit P6, P4, PW4, Exhibit P7, PW4, Exhibit P8, PW4 are the photographs of the CCS car. Now, as per him, material number MO is the videography CD. This is very important, my lord. As per PW1, MO is, my lord, 152 sub cases. And as per PW4, it is, he is the seizing officer, MO is the videography CD.
Yes.
Now, I returned to Delhi police station along with the 2 apprehended accused persons, seized material and car. At Delhi police station, I filed the Ajahar before the officer in charge on so. Is my Ajahar, is a source signature. According to Inspector Mobik Brahma, officer in charge, Delhi police station received the Ajahar and registered the case at Delhi so. As directed to so Ahmed, investigate the case. SI Sanjani Ahmed to investigate the case. Sanjani exhibits P8 by PW signature to Inspector Mobik Brahma, officer in which I know. This is the, now, Lordship, admittedly, he also not exhibited any contraband in the court. The seizure witness. In the court, I think that
Yes.
we can start at 2 miles.
How much time will you take?
Not much
Another
time.
1 hour.
Within 1 hour, it will be over, madam.
Within 1 hour. Then
Not even 1 hour.
will you continue today?
Lordship, initial part.
Okay. So what about others? Should we ask others to wait or there are some other matters?
Or if your lordships permit, then
I like you. Where is Ahmed? Those who has missed the bus, missed the bus. Okay, Musan, you can take up.
Yes.
My lord will kindly come to the FIR, my lord. FIR is at page.
Now, what to be done today?
My lord, considering the
No, I understand.
nature of allegations,
uh.
my lord, I think it's a case where lordship should grant bail. Kindly see, my lord, please come to page 25. My lord, I have deleted the post the moment I got to know it is fake. And my lord, on earth, how 67(6)(f) has been, my lord, 66(f) have been added. Kindly have the IT Act for a moment, my lord.
IT Act.
Yes.
Now, Professor, kindly come to page 20. Your
Order.
Order. During the submission, IO submitted that original version was created by somebody else. So he has published it. Delete it, Metharans there.
I've deleted, my lord. I've made a specific amendment.
At least it's from
tomorrow.
Tomorrow, yes. Because
that's why I was also of view that at least what is their version we should understand.
Certainly. Tomorrow maybe in the second half, my lord. Or in the first. Anyway.
Whenever they bring the seat.
Huh?
I have a DB also tomorrow.
Even in fact, I'll be there.
Yes.
Before rising, my lord, we'll take a chance.
Yes.
At 1 o'clock or maybe 12:30.
I do not think how will that hearing conclusive whole day because we are having bails and all.
Of course, that matter, I do not know whether it will take off also.
But ultimately, we have some bails and all. No? We'll have to.
I have to address, to be honest, well, I do not know whether I'll be able to come prepared. Anyway, tomorrow, my lord.
Tomorrow, case, call for the case diary and list it tomorrow.
Unbudget PS 93.
Just we want to have what was the tweet, how it is.
In fact, my lord, after I deleted the tweet, after 2 hours, I was arrested. And my lord, the inhuman treatment I was meted out is very unfortunate, my lord. And kindly see, my lord, what is how can you on earth you invoke section 66?
We'll see tomorrow what are the materials, then we'll go to go to that what is their initial that necessity of arresting and what if that we'll have to look
and in fact the learned magistrate, my lord, did not consider on the plea of the bar under 437. So my liberty is involved.
Tomorrow you argue. Let them also have a chance.
Yes. Deeply obliged.
So we're on this
PW, my lord. Seizing officer
Mr. Ahmed, you do not think anything will be possible today? What you say, Mr. Kal? He is waiting for the morning. since the morning.
There are two judgments, one passed by your lordship, another passed by another court.
Hmm.
In that case, bail was rejected.
From the same.
Same.
First order was passed by your lordship, therefore registry has placed before this honorable. There is a order of the coordinate bench lordship.
That we have dealt in some other cases also, because in that case, nothing was discussed.
Yes,
We
Lord.
went on our own merit. I think another case, you were also there.
Yes, Lord.
Similar.
Yes, sir.
Where is that case? Subsequently, I have granted bail.
Your lordship has granted bail in 3 cases and rejected in about 3 or 4 cases.
But in the same case says a coordinate bench subsequently rejected, but thereafter again we have granted. Because we express our view that coordinate bench has not gone into detail of whether 37 is satisfied or not.
Yes,
Therefore, we have granted.
That is,
Where is that order?
I'll put it there.
Day after tomorrow.
Lord.
And what about Mr. Singh? Nothing will be possible today. You are enjoying a stay.
Can it be fixed on a particular date?
Yes, madam. Mr. Bora, just wait for a minute. We don't want to keep others waiting.
Very short date, my lord.
Give a date. You others, you give a date and with consent, you take a decision call. Yes, yes. Since you have taken one matter, we will finish it off. Yes, Mr. Bora. And Mr. Ahmed, gave subsequent orders. I have passed. Yes.
Before I start again, my lord, just once, again, lordship, kindly turn to page 76, my lord.
I'm at 76.
Yes, 76, once again, my lord, I'm just pointing out, so that lordship can understand my point. The recovery of heroin was packed and sealed in a cartoon at the place of occurrence, and after signing the...
So it was packed and sealed on the same date.
Same day.
In the place of occurrence.
Place of occurrence. And cartoon was taken to Delhi. Lordship kindly mark it, Delhi police station. That is the second part. Because subsequently cartoon was somehow appeared in another police station, Bukajan. From Delhi to Bukajan, how it has traveled, who has taken it, nothing. That is very important. Now, coming back to the PW4.
This was of PW4, is not it?
PW3.
PW3, just a minute.
PW3 is
DSP.
DSP. She stated that it was handed over to the Delhi police station.
Okay.
Now, PW4. Material object MO. We are on the last part of page 82. I seized the videography CD. So and so Sankar Chetty. I have seen
MO1. We are at that point where you said that
material
object
one
is the
videograph,
videograph, and material object one for somebody is the envelope. PW3 or something.
PW1.
PW1. Yes. Yes.
It is soft boxes.
No, soft boxes. Soft case. PW1, na?
Yes.
Soft boxes is PW1.
Yes.
Now, where will go? 80 page?
Then I return to the Delhi
police
space. Page 82, my lord.
Okay.
Last 2 line, my lord.
Then I returned.
Then I returned to Delhi police station along with the 2 apprehended persons, seized materials and car. So he also, along with this police and the seized materials, he also came to the Delhi police station. I filed an Ejahar before the officer in charge of the Delhi police station. In my Ejahar, my signature is according to the Inspector so-and-so Broming. Accordingly, Inspector Mobik Brahma, officer in charge of the Delhi police station, received the Ejahar, registered the case by Delhi PS case number 12/22 under so-and-so.
This person was a police officer in charge of which police station? Sub-inspector was. He was not the police officer in charge.
PW3.
Delhi.
PW3 is of Delhi.
Delhi. Okay.
Now cross-examination. In the place.
Just give me a minute. Okay, now cross-examination. Yes.
The place of occurrence is 1 kilometer of Delhi police station. I have served notice to the independent witnesses giving the photocopy of the seizure list. GD entry dates was mentioned is 8/12/22. Now the photocopy of the seizure list. The GD entry dated was mentioned 8/12/22, but the seizure list was not exhibited. Now this is the photocopy of the seizure list of the GD entry. So GD whichever has been exhibited, it is a photocopy. It was also mentioned in the GD entry and the FIR that is carried weighing based on from the police station. The seizure lists were kept in the seized article and kept in the Malkhana of the police station, but I did not submit any receipt of the which FIR showing that the seized article were kept in the Malkhana of the police station, but I did not submit any receipt with the FIR showing that the seized article kept in the Malkhana of the police station. This is very important. I did not record the statement of the Inspector Mobik Brahma, officer in charge of the Bukajan police station. Raju Dwara, officer in charge Kotkoti, SI Biplab Das Bukajan, HS Jagannath Pora, Nanda Ranghong. According to the sketch map, Jeet Bahadur Chetri is the owner of the grocery shop. I have not filed any document to prove that Jeet Bahadur Chetri is the VDP Nayak. It is not a fact that you take the exhibit P6, P6, P4, P7, P4 by PW4, exhibit P8 by PW4, photograph of the seized car of the under the sunlight. I did not take the photograph of the decay of the car from the seizure. I recorded the statement of the local witnesses to prove the international cash. I did not investigate the detail of the HDFC account. Computer operator Shankar Chetty is the home guard of the Delhi police station. I did not mention in the FIR that I had taken the computer operator Shankar Chetty along with the studio police officer, but in the mention in the case diary. I did not record the statement of the computer operator. I did not in the fact that I did not take the videography of the incident. That's all, man. Now, he is also absolutely silent about the contraband match. Now, PW6 5 is the FSL. I'll come to the PW5 later on.
Now we'll go to
PW6.
6. Page 89.
89. I know the complainant Latpur Rahman on 9/5.
Which PW6?
He is the my lord Ayub.
Huh?
Ayub. Last witness, my lord. I know the complainant Latpur Rahman on 9/5/2020. I was posted at Bokajan police station as an attached officer. On that day, Latpur Rahman filed an AJAR before Delhi police station. Inspector
No, FIR was lodged in Delhi.
Now he is Bokajan. On that day, the SI Lutfur Rahman filed an AJAR before the Delhi police station. Inspector Mobik Brahma received and registered the AJAR white so and so. Directed me to take up the investigation of this case. Exhibit P8 by PW4 is the AJAR so and so signature. On the same day, as per the direction of the SDPO Bokajan, Inspector Mobik Brahma handed over me the seized material along with the accused person, namely so and so. Now, on the same day, as per direction of the SDPO Bokajan, Inspector Mobik Brahma handover. Now, how it is came to the Inspector Mobik Brahma?
Yes.
Now, Lordship kindly see page 84 again. First slide. Who is this Mobik Brahma?
Page
84 again. Who is Mobik Brahma? Page 84, first line. I did not record the statement of Inspector Mobik Brahma, officer in charge of the Bukazar police station. Now, Lordship kindly see the material was taken to the delay, appeared in Bukazar. Everybody said, my lord, PW 3, 4, that is contraband seized, it was given to the delay at that night. But now, from Bokajan is a different police station, different officer in charge. He has given it these articles to the IO concerned to investigate. Then link, where is that link, my lord? How this has come from Dilai to Bokajan? Who has brought in? Who has authorized to brought in? In what manner?
Yes.
And the Mobik Brahma is not a witness here. On the same day, as per the direction of the SDPO Bokajan, Inspector Mobik Brahma handed over the same to the seized material along with the accused person, namely so-and-so, so-and-so, so-and-so.
Now you are reading at page?
Page 90 again.
Just a minute. Yes. PW6.
And Lordship kindly see, this is a distance between this police station is 50 kilometers. Accused person name is so-and-so. On the same day, as per the direction of the SDPO, I have material along with the accused person, namely so-and-so, so-and-so, so-and-so. Then I examined the complainant, Latpur Rahman, recorded the statement under 161. Then I interrogated accused person, so-and-so, 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 recorded their statement under 116. I found the sufficient material against both the above accused person wherein the involved in the case. I arrested both the accused person so as to family members, both the accused person came to the police. I informed them the family members. The occurrence took place on 8/5/2020 at the time of so-and-so, so-and-so. Setri made a videography of the incident. Hence, I see the CD, took the certificate under the section evidence section. Material exhibit M1, M is the seized videography CD again. That is the material exhibit in the court. On the same day, on 9/5/2022, I produced both the accused person along with the seized article before the deceased lordship kindly see. This is very important now. On the same day, that is on 9th. Lordship kindly mark it, very important. On the same day, on 9/5/2022, I produced both the accused person along with the seized article before the court of JMFC Bukajan, where I submitted a prayer before the Honorable Court to allow the accused person for 10 days police custody. But the Honorable Court allowed that 4-day police custody of the two accused person. So, on 9th, he has produced seized article before the magistrate. As per his deposition. Now, on 10th, again I brought the seized article before the learned magistrate Bokajan. So, 9th he has produced, taken it back. On 10/5/2000, I again brought the seized article before the learned JMFP Bokajan. Before the learned JMFP Bokajan, I weighed the mark and represented samples of the recovered heroin. I made total 30 samples for sending the sample to the forensics and laboratory examination. Now, PW, these are exhibit P11, P12, P13. These are all photographs up to P24 of the weighing and making the representative sample before the learned JMFC, and P25, this is very important, is the certificate given by the magistrate under section 52(3) of the NDPS Act. Now, Lordship, I'll again come to some. Now, here is 2 points. First of all, on 9th, he has produced the material before the magistrate. He has took it back.
Yes.
Then again, 10th, again he has produced it before the magistrate and prepared the inventory. And certificate was taken from the magistrate regarding the inventory.
Where have you kept this 9?
Now on the 9th, there is nothing where he has kept those articles. No Malkhana register was produced. No evidence to that effect that it was in the safe custody. Not even the deposition, oral also. Now, exhibit 25 happens to be the inventory.
Exhibit P25, yes.
P25 is the inventory which was given, the certificate was given by the magistrate regarding the inventory prepared regarding those seized articles. Now, Lordship, kindly see the inventory in the original copy. I have shown it before your Lordship. That is my copy. They have marked this as P26.
Inventory.
Inventory. I'll see, my Lord. We have marked it also as an inventory.
Yes.
Whether this is exhibited, my Lord. This is the original copy.
Now, where is this is the exhibit file.
But this is now exhibited. Not exhibited.
We thought that certificate was not, signature was not exhibited.
Even the document was
is
also not exhibited. Even that document was also not exhibited. No. And the one more point, in this inventory, my lord, there is no mention that the seized article was opened and the separate 30 packets has been made out of these seized contraband. That inventory only says what has been seized. That the total number of 152 number of soft boxes marked as 1 to 52 contains plastic pouches, each filled with brown color powdery substance. That is the only inventory. I'll come to the judgment of what is the actual inventory has to be made.
Yes.
Now, again, I return to the Bokajan police station along with the samples. Now again, Lordship, can you see? This is very important. Then I return to the Bokajan police station along with the samples and seized article. Then I again interrogated both the accused person, but they have stated same statement earlier also was recorded on 10/5/2022. Hence, I had not recorded the statement again. On 11/5/22, I, along with the officer in charge of Bokajan police station and staff, wanted the Senapati district of the Manipur with this so-and-so. Now he visited the Manipur, that's not important. Now the second, on 12/5/22, again I interrogated both the accused person, but but they have stated the statement earlier so and so as recorded on 10/5. Hence, I had not recorded their statement on the same day. On completion of the police remand period on 13/5/22, I forwarded the accused person to the Honorable Court so and so judicial custody. On 22/7/22, I received the forensic science laboratory report. Then I perused the case diary. I found that investigation of the case was almost complete. Hence, I so and so charged on so and so, so and so, and so and so and so. Final report is exhibited. Now cross-examination. Now, in the Chief Lordship kindly mark it. On which date he has specifically sent it to the FSL. No whisper to that effect. Neither there is any whisper that after the purported inventory, again the material was sealed and kept in this Malkhana and forwarded to FSL . Because as per the inventory, it was on 10th. Then again he has received it back. As per the forensic letter, it was received on 12th. So from 10 to 12, 2 nights, 10th night and the 11th night, there is no whisper that again this, after when the contraband was separated for the sampling. Suppose, because in the evidence there is no sampling. As per the evidence, there is no sampling. That I have separated, I have made 30 samples out of the entire things. Then 15 was sent to the FSL, 15 we have kept it. There's nothing. But let us assume it that yes, he has taken it back again from the magistrate court. But where he has kept it? On 10th night, on 11th night. Again on 12th, through a special messenger, he has given it to the FSL for examination. So again, 11th night, 12th night, there is no Malkhana register, nothing on record, no deposition that it was in the safe custody of me, even to that effect. Not even to that effect that it was in the safe custody with me and it was under the sealed condition. Now cross-examination. On that the occurrence, I was not present at the place of occurrence. Spot sample was not taken by me. The name of the videographer is so-and-so, not in GD entry. I have not recorded the statement of the witnesses as mentioned in the FIR, so-and-so, not important. The complainant SI Lotpur recorded the statement of witnesses so-and-so, so-and-so, so-and-so. Now, complainant SI Lotpur Rahman recorded the statement of the witnesses, namely Sri Jit Badu Chetri, Abdul Ali, Nahid Karishma. Now, who has recorded this, my lord? The complainant himself.
That is why I ask you, who was the investigating officer?
One part is the complainant himself.
That's why I asked that who is the actually. So because earlier I could read that he recorded the statements.
Yes. So
witnesses.
The main witnesses, the Nahid Karishma, who is the star witness of the entire prosecution. His statement was recorded by the complainant himself.
He was PW4.
Yes.
Nahid.
Nahid 3 and seizing officer is 4. I recorded the statement of both the accused person. I have not taken the signatures of the accused person along with the date of their statement. PW1 stated before the Honorable Court that he went from the home to so-and-so to Dimapur along with the passenger, but during the investigation, I have not examined the passenger who was present along with the PW1. On 10/5/22, this is important, Lordship kindly mark it, this evidence. On 10/5/2022, I draw the sample of the heroin before the learned JMFC Bokajan. I have sent the sample to FSL for examination on 12/5/2022. But I have not mentioned the reasons for delay of 2 days of sending the sample to FSL in the case diary. On 10/5/2022, I draw samples of heroin before the learned JMFC Bokajan. I kept the samples of Bokajan at Bokajan Police Station, Malkhana. I have not mentioned maintain any register of the Malkhana. This is important. I have not recorded the statement of the Shirastidar of the Malkhana Bokajan police station. In the same Malkhana, seized items of the other cases are also kept. This is also important. Out of 30 samples, I have sent 15 samples to FSL for examination. Rest 15 samples were kept in the Malkhana of Bokajan police station. The samples were sent to FSL by a messenger, but I have not examined the said messenger. I have not made him witness in this case. After examination, the samples were sent back to the FSL to the police station. That is, Lordship, kindly mark it again. The seized drugs were not destroyed by us. Again, Lordship, kindly mark it. That's very important. Seized drugs were sent to the Honorable Court through challenge, but the said challenge was not attached to the case record. The drug testing case, this is not important. So, now Lordship, kindly see, there is no Malkhana register produced. No Shirastidar, the in charge of the Malkhana, been examined to prove the safe custody of the contraband. Neither there is any oral deposition to the effect that the seized article being kept in the safe custody. Now, the most important part here is the forwarding to the FSL. No forwarding to that effect. That those articles which has been sealed and prepared for the FSL, for sending it to FSL, samples. Only evidence is that the samples were sent through a special messenger. We don't know who is this messenger. He has not been examined. No forwarding. That's very important. Now, which material you have forwarded, my lord? Who can prove that, my lord? That the actual, the sample which has been prepared, let us presume it, that the sample has been prepared without inventory before the magistrate. Let us assume it that yes, magistrate, as per his official capacity, in front of him, he has complied the provision. Let us assume it. Let us take it to be a correct one. Even then, there is no evidence to the effect that the sample prepared for the FSL that was forwarded. Now, FSL again, they have tested the samples. The remnant of the samples, again they have sent it back. That is the evidence that after examination of the samples, they were FSL again sent it back. That the remnant was sent back by the FSL. There is no forwarding by the FSL. The most important factor is that no contraband was produced in this court. Not even the remnant, not even the seized material. No contraband, mine. Because it has to be proved that this material was forwarded to the contraband. This contraband sample was taken from the contraband. This sample was forwarded to the FSL. Then FSL has tested those samples with the remnant. They have to forward it to the court or to the police, which will be again exhibited in the court that these are the remnant and these are my report. Now, the FSL man also has not seen the remnant in the court. He has simply exhibited his document, the test report. that whatever we have received, now some samples they have received, and it also does not tally. That is very surprising. That's one more factor. Now it proves rather that there is something fishy about it. It has been changed. What has been taken, it has not actually been sent to the FSL. From the magistrate record, I'll show it to you. Though it is not exhibited, even for the Lordship's convenience, I don't want to hide anything. Magistrate not examined. There is no, admittedly, there is no inventory. But as per the record, I have checked it. The magistrate in his order, he has prepared some kind of inventory.
But that was not part of the exhibit.
Not part of the exhibit. Let us assume it. We are not challenging it, but let us assume it that it was done in due order. But what exhibit he has forwarded, it was marked actually. He has forwarded the 2 samples has been made by from each box. They have marked it as in one is A, one is B. Now, as per the magistrate record, the A samples was given it to the FSL. It was marked for FSL, and the B was for the police, rest of the part. And the weight is also mentioned. Every A, sample A,
Lot 1 sample A.
they have marked it as lot 1 sample A to lot 1 sample A. So everything is A. And the weight is also mentioned as per now. Lordship kindly see the evidence of deposition. Evidence of PW 5. The page mark is PW 5. What he has exhibited.
Page
86.
Page 86. No? Page 65, Lordship Kanitra.
It's 65.
65.
65 is the FSL report.
FSL report, that's very important, which has been exhibited by PW 5. Description of the article, madam. Lordship kindly see the 15 numbers of seal envelopes marked as lot 1.
Lot A,
Lot 1 sample A to lot 15 sample A, each having closed polythene packets containing. Now this is important. Lordship kindly now file A. Lordship kindly see the file.
Destination.
Page 5 of the lot A.
Page 84.
File A.
Oh, file A. Where is it? Page.
Page 5. File A, capital A.
Yes.
Now lot 1, Lordship. Lot 1, Lordship has
Yes.
found that column, my lord. The right hand side is lot 1. A and B. A samples, what they have FSL has received is the A sample, my lord. Admittedly. Now, what is the quantity? 5.65 gram. First one. Lot 1, 5.65 gram. Now, Lordship kindly see
5.31.
In the FSL, it is 5.31. Sir is reading from.
Yes, lot page that lot is 5.65.
5.65.
And in FSL it is what?
No, FSL nowhere, Lordship kindly see. Is there anything?
5.31.
One is 5.31, 5.52, then
5.51,
5.51, 5.8,
5.62,
5.62, 5.41,
5.51,
5.51, 5.48, 5.75, 5.61, 5.67, 5.81, 5.61, 5.1, 5.7. Lordship kindly compare it. Is anything
with the
that's
file?
it?
No.
Not even a single. Only one. There's one matches the gram, that is 5.51.
Lot B.
And that too from lot B. Only one gram it tells, my lord, it comes 5.51. But 5.51 lordship will find it is in lot 6 sample B.
Yes.
That's all, man.
Yes, PP.
Now, if the lordship permits, I can place only the judgment. Man.
Okay. Mark the paragraphs.
Yes, I'm marking paragraphs. I'll start with the recent judgment, my lord. The only paragraph is the first one. On to paragraph 20. 2024, my lord, SCC online. Para 17, lordship. Paragraph 17, 21, 22.
17, 21. 17, 21, 22.
Yes, lordship can. Before discussing the prosecution evidence, we would like to note
Space.
Paragraph 17.
17.
That the case set by the prosecution is regarding the recovery of the narcotic from the vehicle which is stopped during the transit. Thus, the procedure in search and seizure would be governed by section 43, read with section 49 of the NDPS Act, which are reproduced below. Now, this is the sections, my lord. 49. Also, any officer authorized under section 42. So this is the now. Then 19. 19 is not very important. We'll directly go to 21. The sub-inspector LW10, who prepared the sample of ganja as per the testimony of PW5, was not examined in the evidence. In addition thereto, the prosecution neither examined any witnesses nor produced any document to satisfy the court regarding the safe keeping of the samples right from the time of seizure till the same is reached to the FSL. The official who collected the samples from the police station and carried to the same to the FSL was not examined. Same as my case, my lord. At the trial, from the quoted portion of the evidence, seizure officer, inspector, it is clear that as the daylight that he handed over one of the 3 samples to the accused. The witnesses also admitted that he did not mention about the sealing of the samples and the panchnama. Contrary to the evidence of the PW2, PW has stated that the 3 samples of ganja were taken out by the sub-inspector LW10 were handed over to the witnesses who forwarded the same to the ACP for sending to the FSL. In the cross-examination, the witnesses admitted that he did not file any document to show that the property was kept in the Malkhana. The Malkhana register, this is important, the Malkhana register was not produced in the court. The FSL report, exhibit P11, does not disclose out the punch sheet and the seal and the signature of the accused on the samples. Here also, there is nothing, seal, signature, nothing mean, because it has to be under the seal condition. Then the remnant of the seal also needs to be exhibited by law, so that the prosecution can prove that it was sent to the FSL under the seal condition, and the FSL will, after the opening the seal, they also forwarded that sample of the seal to the court that we have received under the seal condition, and this is the remnant of the seal. Here also, in my case, there's nothing. Not even a whisper regarding seal signature of the accused.
Only the report.
Only the simple report that has been received. No material at all. No malk. The property deposited in the court was not having any official seize. The witnesses also admitted that he did not take any permission from the court for changing the original 3 packets of Mudamol Ganja to 7 new bags for the safekeeping. These glaring loopholes in the prosecution case give rise to an inexplicable inference that the prosecution has miserably failed to prove the required link of evidence to satisfy the court regarding the safe custody of the samples package from the time of the seizure till the time reached the FSL. Rather, the very possibility of 3 samples being sent to the FSL is negated by the fact that the seizure officer handed over one of the 3 collected samples to the accused. Thus, the entire, similarly in my case also, from the document of the magistrate, it appears because the weight does not tell you with the FSL report. So it is rather appears that the whatever prepared by the magistrate, it was not forwarded to the FSL. From the weight. Yes. Now, he admittedly, next paragraph, 22, admittedly, no proceeding under section 52A of the NDPS Act were undertaken by the investigating officer for preparing an inventory and obtaining samples in presence of the jurisdiction magistrate. In view of the matter, FSL report is nothing but a waste paper and cannot be read in evidence file. Exactly the same scenario, my lord.
Okay, next.
So, my lord, lordship can see here also, as per the section 52, my lord, of the NDPS case, A, there is a procedure has been prescribed. There has to be an application before the magistrate concerned for preparation of the inventory. For 3 different purposes. For inventory, for sampling, there has to be an application, and accordingly, magistrate will decide in presence of the magistrate. Let us see, but the inventory prepared by the magistrate does not say about the sampling here, and the original inventory is not been exhibited. Neither the signature of the magistrate is exhibited, nor did that particular magistrate was examined. Why not? And if you take it as an assume it is a correct inventory also, it does not tell you with the FSL report. So FSL report here also nothing but a waste paper. The second one, my lord, 1993 supplementary Supreme Court, my lord, 665. Paragraph 4, my lord. Yes. We have seen the report of the chemical examiner, and there is no doubt it is mentioned that one sealed parcel was received containing a powder. It was analyzed to be the brown sugar. But from the record, it's clear. It is also noted that both the courts below that the seized article was produced in the court only on January 14. In my case, not been produced after a period of more than 3 months. In my case, there is no production of the material, my lord. And there is no evidence whatsoever that all to show that with whom the seized article was lying, and even assuming that it was in the custody of PW6, the officer in charge of the police station who seized it, there is again nothing to show whether it was sealed and kept there. The learned counsel of the state has no doubt argued that provisions of Section 55 Act are not mandatory, but only directory. We need not go into the legal question as to the case. The suffice is to say that the article seized appears to have been not kept in proper custody and proper form, so that the court can be sure that the seized only was sent to the chemical examiner. There is a big gap and important missing link.
Yes.
There is a big gap and an important missing link. The Mazahar Exhibit P2, which is immediately said to have been kept after the seizure. Unfortunately, the prosecution, even PW6, does not say that he continued to keep it in his custody under the seal till it was produced in the court in January 14 or so and so. The evidence given by PW6, the police sub-inspector who seized the article, is absolutely silent as to what he did with the seized article till it was produced in the court. In my case also, my lord, similar. No evidence to that effect. On 9th, he was taken it back, produced it again on 10th, again he took it back, 10th night, 11th night, there's nothing on record where it was kept, only said it was kept in the Malkhana. No register, nobody, nothing was. As a matter of fact, he did not produce in the court. Just I am reading from the specific C, my lord. Therefore, the evidence adduced, evidence produced is wholly insufficient to conclude that that was seized from the appellant alone was sent to the chemical examiner, sir, though it was purely a question of fact, but it's an important link. So, the judgment of the High Court has been set aside, my lord. Now, Lordship kindly see. Issue 2. Issue. Now, 2005 3 SCC 59, my lord. Paragraph 3, just 2 pages, 1 page judgment. Paragraph, we have perused the judgment of the High Court. Apart from other reasons accorded to the High Court, we find that the link evidence adduced by the prosecution was not at all satisfactory. In the first instance, though the seized article was said to have been kept in the Malkhana on 25/95, the Malkhana register was not produced to prove that it was so kept in the Malkhana till it was taken over by PW6 on 6/5/6/95. We further find that no sample of the seal, this is important, we further find that no sample of the seal was sent along with the sample of the excise laboratory.
Yes. Yes.
We further find that, paragraph 3.
Yes, we are talking this.
We further find that no sample of the seal was sent along with the sample of the excise laboratory, Jodhpur, for the purpose of comparing the seal appearing on the sample bottles. Therefore, there is no evidence to prove satisfactory that the seals found were in fact same seals were put on the sample bottle immediately after seizure of the complaint. So, what is the required as per the 52, my lord? The contraband after seizure there has to be sealed, my lord. And that seal, along with the specimen, has to be sent to the FSL. So it will return to the court. The court will compare both the seals with the signature of the accused. There is nothing of that sort. In fact, in my case, there is no contraband at all. Now, the last one, my lord. Our Guwahati High Court judgment, my lord. And it was argued by none other than by my senior, my lord, James Chaudhary, my lord.
Yes.
The paragraph 3. It is by B.D. Gyani, my lord. The learned counsel appearing in the appellant has assailed and findings mainly on the ground that there is no sealing of the articles which it was actually seized, and there is no evidence adduced by the prosecution to show that the article seized from the possession of the accused remain intact till it was produced before the magistrate and thereafter sent it and received by the State Forensic Science Laboratory. There is not a slightest whisper in the evidence of PW5 that the samples are as received by him was intact and sealed thereon, daily with the specimen seal and impression separately sent to the forensic science laboratory. Then next, my lord. 5. Para 5. In a similar circumstance arising of the so-and-so case 1980 SC, which is also case of seizure of opium article having passed through the hand to hand, Supreme Court was held. It was admitted case that the prosecution that the sample changed several hands before it reaching the public analysis. In my case also, as a lordship seen, from one police station to another police station, there is no link at all. Who has sent it, who has taken it, how it has gone. The chain of custody is not been proved by the prosecution. In the other words, the sample remain in the custody of SI, Uday Mande so-and-so, and the assistant public analyst, and yet none of these witnesses was examined by the prosecution to prove that while in their custody, seal were not tampered with. The inevitable effect of the omission is that the prosecution failed to rule out the possibility of the samples being changed or tampered with during this period, a fact which has to be proved affirmatively by the prosecution. In my cases, rather it was proved that the sample has been tampered with because it is the weight does not tally. In other cases, the court has taken a view that the seal was not there, is the chain of custody is not proved. If the Malkhana register is not, it is the court has assumed it that there is a chance of tampering. But in my case, more than that.
Yes.
Apart from these, there is a apparently which has been sealed, which has been sent to FSL does not tell it.
Okay.
My lord, the last line, the paragraph 6, last line. It last fourth line, fourth line, my lord. Apart from the non-compliance of the section 50 and failure on the part of the prosecution to prove by adducing affirmative evidence that the seized articles as seized from the accused were kept intact and untempered, even the evidence taken on its merit does not such to prove the charge beyond reasonable doubt. In my case, doubt is apparent from the FSL report itself, my lord. No doubt at all, actually, my lord. Doubt is rather clear, my lord, that whatever the material has been seized, it was not sent to the FSL. Even that is sufficient to acquit the apparent, forgetting all the other evidence, my lord. Even the chain of custody also. Only that part is, if we go by that part only, whether the sample prepared in front of the magistrate is forwarded to the FSL or not.
Actually, that is the sample that has reached the FSL. That is the question.
Yes. But apparently, both does not tally. No forwarding, nothing. Weight does not tally. If the weight does not tally, what does it mean, madam? At least some weight has to be tallied. Not a single weight has been tallied, madam, of the sample A. Only one lot of the sample B, that too. And in my case is that, my lord, only that the chain of the custody. This is apparent. Absolutely missing link, how it has been kept, how it has been produced. And the most important fact is the last nail in the coffin. Where is this the material contraband, my lord? Nobody has produced it, my lord. Not destroyed, nothing.
Now, just for my knowledge, how is to be dealt with after a conviction is or an acquittal is there? There are some material that is forensic is seized. What about the destruction and all?
Destruction, it can be done beforehand also, my lord.
Before
During the
just for my knowledge, out of this context of this case,
there has to be the application has to be made.
Suppose there are materials that 120, 152 soft boxes, these were brown sugars. Where those materials has gone? Just for my
Yes, ma'am.
No,
as
in
per
this
my lord-
case, nothing.
No, that's why I'm
Yes,
asking.
my lord.
And
My lord.
otherwise, what is the procedure?
Otherwise, procedure is that during the trial, my lord, also that can be destroyed, provided there is an order of the magistrate, my lord.
But when materials are there, then only question of destroy will come.
Yes. No, they have said that you have not destroyed the material.
That's why I have seen that.
That's why I'm saying that if they have not destroyed the material, it has to be before the court. It has to be exhibited, material exhibit. Now, Lordship, can you see the material exhibit? M1 is sometimes it's become a soft box and sometimes it's become a video CD. And IO himself said it is a video CD. Seizing officer, M1.
And he is confident.
It is M1. Nobody, where is that? It is evaporated in the thin air, my lord. If the contraband is not before the court, not even a samples, nothing, my lord. It's a clear case of acquittal, my lord, even a glance.
My lord.
Today?
Next week, my lord. But let it be parted, my lord.
Parted. Of course, we have spent 3 hours, 2 hours,
Yes.
more than
Only
almost
thing,
3
my lord,
hours.
regarding samples, what my learned senior friend has raised, my lord. Only that I will check from the records, my lord.
You check from the
Then-
record, but
I
don't
have
re-
checked it, my lord. I have
Yes.
shown it. Even I have gone beyond that
Yes.
because it was not in their evidence that the magistrate has prepared these samples. It was not their evidence, my lord.
because this casually they have exhibited the inventory, which is nothing is there. That these are the samples, these are
Yes,
the weight,
even that
these are the same.
inventory is not that inventory. Original was not exhibited.
So even if assumes that that is the inventory, suppose.
Yes.
Then also the
That
inventory discloses nothing
Nothing.
except 120, 152 soft boxes.
Yes, 152 soft boxes.
And
And
your case is that was removed, that was sealed in 15 separate boxes. Where are those gone?
no, nothing.
And we have sent it to it. And the FSL says, this is the report. Report of what? Which was sent to you and this is the,
Yes.
is that it?
Is that? That's why I'm saying even I have gone beyond that. I have not argued that it was, even the magistrate had let us prepare the
In fact,
inventory.
the magistrate has done his job.
Yes. Magistrate has prepared at least something. He has prepared it.
And
A
this
and B.
Bokazan and Delay.
Yeah.
See, he even forgotten which police station he was.
Yes. And how it is came from Delhi to Bokajan.
He should not be so casual.
Nowhere, my lord. How it is came to, and the 2 nights, only
There
2
are
kg.
some people like Mr. Bora who knows how to create a doubt.
Yeah.
And
No, my lord.
irrespective of NDPS whatsoever,
Yeah.
the foundational fact is to be, presumption may be otherwise, but foundation is to be laid by you.
In this case, even I don't have to create the doubt even.
That's why
Doubt is apparent on the record, my lord.
That's why I'm saying foundation, basic foundation. Then it will take
Yes.
them that what is your
Yes,
defense.
then
Why-
the rebuttal part is mine.
Yes. Be more particularly NDPS.
NDPS. Because there is a
That's why so strict, not doing a simple thing by
Yes,
the
sir.
image. That's why.
even that
Otherwise, if it would have been a case otherwise that no, it is absolutely upon you, then certain lacunas here and there we could.
because there are few judgment, my lord, that when the stringent punishment is
Yes.
prescribed,
The
the
prescription
procedure has to be
strict-
followed very
strictly.
There cannot be any loophole.
Anyway, we'll hear you. We have not
Yeah.
made up our mind.
Got
Just
it.
this is the
Yes.
uh, hard in part. Mr. A.M. Bora, learned senior counsel, has concluded his argument. However, due to paucity of time, Mr. Goswami, learned additional public prosecutor, could not complete his argument. Accordingly, list this matter on next Thursday,
Lord.
9.
9th.
Nine.
Next Thursday
Right.
for further hearing.
Obliged.
Motion to make
My
it
job will be, my lord, to clear some doubts, my lord, to clear those doubts, my lord. My lord.
একটু important, না এখানে বস্তু। Yes, পড়তে পাঠান।